Okay, we're good.
Thank you. Good morning. This is July 26th and the fourth day of evidentiary hearings in the case of SouthCoast Wind, Brayton Point, EFSB 22-04. My name is Robert Shea. I'm the hearing officer, presiding officer assigned to this case. Let me first introduce the other members of the siting board, the staff that are on this video conference. That would be Andrew Green, who is the director of the siting board staff, Joan Foster Evans, who is our general counsel, Wayne Wong, who is the assistant director of the siting board, and Smitha Devakar, who is one of the analysts at the siting board staff. I'll ask counsel to introduce themselves.
Good morning. This is Eric Runge with Dave Pitney, and I'm here for the company. Address of 1 Federal Street, Boston, Massachusetts. Gemma
Cashman, also from Dave Pitney, representing the company.
Thank you, Ms. Cashman. Mr. Pucci?
Yes, good morning. This is George Pucci from KP Law in Boston, and I am counsel for the intervener town of Somerset.
Thank you, Mr. Pucci.
Mr. Shea.
Yes, sir.
Ms. Seafield is also with us here today.
Yes.
Ms. Seafield, of course.
Morning, Margaret Seafield from Dave Pitney on behalf of the company. Address of 555 11th Street Northwest in Washington, D.C.
Okay, before we get to the introduction of the witnesses, Mr. Pucci, I believe you had something that you wanted to say regarding the your motion to stay the proceedings.
Yes, thank you, Mr. Presiding Officer. Just briefly, and I don't intend to try to be rhetorical or argue my motion at this time, but I did want to raise formally to the siting board. We had filed a motion to dismiss and or stay these proceedings based on the termination of the existing power purchase agreements, consistent with what was done in Rhode Island. The initial motion was opposed by both the project proponent and an interested party. We filed a reply to that on Friday afternoon, that is before the siting board. I changed the relief that we're seeking, considering it further that I am not seeking to dismiss these proceedings anymore, but rather to maintain the existing record as it is, including anything that we do this week, and preserve that record, stay the proceedings, and then reopen the record consistent with the time frame set forth in Rhode Island. So I just wanted to note that on the record and respectfully request a ruling on the motion from the siting board. Thank you.
Okay, and so you wanted to stay the proceedings. You say consistent with the Rhode Island decision, but could you be more specific about that? Stay the proceedings for how long?
I don't think it has to be exactly in line with the Rhode Island stay, but I think it would make sense at least to have the stay concurrent with the bidding process on the next round of bids for the power purchase agreements. So if you wanted to, have a date for a status update as of a certain time, January, or a time subsequent to that, and then a further status report as to whether SouthCoast Wind was a successful bidder on that next round of bidding. I'm very flexible on the relief that I'm seeking, but I think it's a fundamental legal issue of proceeding without the power purchase agreements in hand. So I did want to raise the issue, but I would be very flexible in terms of if the Massachusetts siting board were inclined to issue a stay, whatever the board would find sensible would work for me. So I would suggest, initially maybe a status update in January of 2024, and then you decide at that time, and further proceedings or to complete the proceedings or complete the record could then be subsequently scheduled. I'm not even sure my stay requires, further evidence, I would think that it would be limited at that time. So I'm not seeking to drag out or unduly complicate the proceedings, but I do think it's a fundamental issue that we can't proceed and finalize the record until we have certainty about the success of the proponent on the next round of bidding.
Okay,
So I'd suggest a status report in January of 2024.
okay, thank you.
Jay,
This is not right. This is not oral argument on the motion, but I think Mr. Runge, you both had something to say, and I think that you have a right to respond to Mr. Pucci.
thank you. And the company opposes the request from the town, not surprisingly. We will have a certify that we're filing today. It's already drafted. So that will be coming in. The request is now for a mere delay of a year for this project, which would have the same kind of adverse effect on the project as a motion to dismiss. So we're strongly opposed to any such delay. We want to continue. We think everything you need is in the record or will be in the record by the time we close out this hearing, and that you can make your decision based on the standards in the statute right now. So that's the point on that. I did have some other remarks, but I'll wait and see what you want to do on this one, Mr. Shea.
Yeah, no, I'm not going to rule on this. What did you say you have ready to file today?
We have an additional reply, a certified,
Okay,
and it will be going in this afternoon. And it will address the arguments that were made in the reply related to the now request for a stay. It will address the arguments related to the Rhode Island EFSB order. So this is new information. It will assist you in your decision making and the citing board in its decision making about the motion.
okay, thank you. Obviously, I can't tell you when we will rule on this motion. Any sort of motion of this size and importance is something that many people review and many people have input into, because it is so important, and it is a citing board. It's not just it's not the sort of thing that a presiding officer himself would just rule on, like a motion to exclude, an objection to evidence or something. So thank you for that, Mr. Runge. Now, there was something else that you said that you wanted to say?
Right, I just have a few quick remarks before we get started today. First was thanks again for this past Monday back. The unexpected gain of a day is always a welcome thing, so we appreciate that. Second, for the record, the company filed its final environmental impact report last Friday. That report was the subject of some discussion over the first few days of hearing, and now it's in the record. There was a follow-up filing on Monday with confidential attachments. I know we had some discussion already about maybe having another day of hearing to talk about the FEIR, and we are going to try to accommodate that the best we can. So that's out there. Third, the company has provided a lot of relevant information on the project and the applicable standards in this proceeding, including in the hearings and discovery, in supplemental filings and pleadings, and in the initial petitions themselves. So now we're drawing near to the conclusion of the evidentiary hearing. We just want to see whether the staff has anything else they think they need to make the appropriate findings regarding the petition. So, sometime over the next 2 days, I'm sure you'll be doing this, but just wanted to put that on the record. If there's anything else that we can provide informationally, we want to do that. Fourth, so today we're going to be discussing, among other topics, zoning, community outreach, and the town's concerns about local impacts. And we've tried to have the right witnesses here to answer questions today. And as you saw, we also have my colleague from Dave Pitney, Gemma Cashman, whose appearance has been noticed, and who is a land use and zoning counsel. To the extent she's able to help clarify points about zoning and land use and related matters, she will try to do so. I note that during discovery, there were several questions related to zoning that called for some legal analysis. And if we do get questions like that today, I think Ms. Cashman or others might try to assist by providing a high-level response along with the fact witnesses' response. But if, However, we do get questions that call for any substantial legal analysis. I'm going to ask the questions be provided as a record request so that the company can provide a considered and written legal response with input of counsel as appropriate. And this approach will provide for a better record and a more efficient use of our time together in hearing. And
Okay.
finally, yes?
No, I just said, okay, that's fine.
Yeah, and finally, on July 18th, the Pucci stated he would provide a valid response to the information request directed to the town by the EFSB and the company. I still haven't seen that. As you recall, the responses to information requests by the town were not valid because they were not connected to a witness and they were not signed under oath. Now that we're getting near the close of the proceeding, the hearing at least, it would be appropriate for that to be filed today. And I just wanted to see whether that is going to happen or not.
Mr.
Those are
Pucci?
my initial remarks, and thank you for allowing them.
Thank you, Mr. Runge. Mr. Pucci?
Yes, on the witnesses, the deadline that you set last week was before they testify tomorrow. So we're anticipating filing that today.
Okay,
Thank you.
thank you. Mr. Runge, would you please introduce the witnesses that you have here today?
I will. So today we have with us some mostly returning witnesses. They include Kathleen Freeman, Daniel Hubbard, Jennifer Flood, Kelly Smith, Tim Ryer, Jamie Duran, Andrea Wood, who I think is remote and may join us, and Sam Ashe. We also have one new witness who will need to be sworn. That is Kelsey Perry.
Okay, thank you. Why don't we then proceed to the swearing of the new witness, Ms. Perry. Ms. Perry, would you please raise your right hand? Do you swear or affirm that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Very well, thank you. So let the record reflect that Ms. Perry has been sworn. I understand all the other witnesses have been sworn. You understand, just address, this is addressed to the other witnesses, you're still under oath. Mr. Runge, do you have direct examination for Ms. Perry?
Yes, Ms. Sepia will be conducting that.
Okay,
Yes, good morning. Good morning, Ms. Perry. Could you please state your name, business affiliation, and address for the record, please?
Sure. My name is Kelsey Perry. I am the Community Liaison Coordinator for South Coast Wind, and I'm at 101 Federal Street in Boston.
Okay, and on whose behalf are you testifying in this proceeding?
On South Coast Wind's behalf.
Are you the same Kelsey Perry who sponsored information request responses in this proceeding?
Yes.
And I believe you already stated your role with South Coast Wind, so could you please describe the general topics you're prepared to testify on today?
Yes, I am prepared to testify on community outreach, environmental justice, and local zoning related matters.
Great. And was your resume submitted as an attachment to the participant list filed by South Coast Wind in this proceeding?
It was.
Have there been any changes since its submission?
No.
And were the responses, including any supplemental responses to information requests that were submitted during the course of this proceeding that bear your name, prepared by you or under your supervision?
Yes.
And do you have any changes to offer for the record at this time to any of the materials that were submitted under your name?
No.
Do you adopt all of those materials as your testimony in this proceeding?
Yes.
Okay, Mr. Presiding Officer, I think Ms. Perry and each of the witnesses are ready for further questions. Thank you.
thank you, Ms. Sepia. Does anyone, I was going to start questioning, but does anyone else have something that they need to say or before I start questioning? Not hearing anything. Let's wade in here. My first general area is consistency with the policies of the Commonwealth. In the initial filing, there are a lot of references to, quote, RPS. For example, the analysis at 5-42 and 5-43 states that, quote, Mayflower Wind and RPS are working together to sponsor and provide local Native American communities with cost-free training and all certifications required to work as a protected species observer. I have looked through the various documents and I don't find an explanation of what RPS stands for. What's the full name of the entity?
Identify yourself.
This is Kelsey speaking. I am not familiar with the full name of the entity. Do you know?
Yeah, this is Jamie Duran from Power Engineers, RPS Group.
RPS Group?
RPS Group.
Identify what it is.
RPS Group is a we do a lot of marine science type of work. They've recently been purchased by Tetra Tech. I think a lot of you have heard from Tetra Tech. They do a lot of large offshore wind projects. But RPS is more marine-based fisheries, benthic studies.
And where are they headquartered?
I'm looking right now. I know they have a location in South County, Rhode Island, and I will check the next location. They have an office. There's an office in South County. There's also an office in Boston, Massachusetts.
20 Park Plaza.
I'm sorry, what Park Plaza?
20 Park Plaza.
Okay, and you stated that the work that they do, but are they a group of engineers? Is that what their primary, or what is their expertise?
Yeah, I think they're mostly a group. This is Jamie Durand again from Power. They're mostly a group of marine scientists, physical oceanographers, marine ecologists.
Okay. That's helpful. Thank you. And which individuals from RPS worked on preparing the initial filing and the responses to the information requests?
This is Kelsey. Our partners at RPS, they didn't help prepare the information requests.
Okay. Did they help prepare the analysis?
No, they helped develop the Protected Species Observer program.
Thank you. On another subject, going to the FEIR, attachment B to the FEIR contains a table that's entitled Log of Agency Meetings and Consultations since filing of DEIR with MIPA office. And I'll let you refer to that attachment because my first question is, have any of the public meetings designated in attachment B been held in environmental justice communities? And if so, which ones? You may want to consult with the attachment though first.
While Jamie's looking, this is Kathleen Freeman. Our cover letter to our FEIR filed on Friday provides an updated summary of our environmental justice meetings. You want to pull that?
The cover letter dated July 21st, 2023.
That is correct. Actually, I'm pulling up the cover letter right now.
Thank you.
We believe, signed by our CEO since the filing of the DEIR. South Coast has been implementing a community outreach plan consistent with its commitment to environmental justice and to robust community engagement. I'm reading from our FEIR cover letter. And for example, since publication of the DEIR, South Coast hosted 3 in-person public forums for Somerset and surrounding communities, including Fall River, which is mapped environmental justice. On April 20th, 2023, South Coast gave a project presentation and took questions from over 60 community members. Also, South Coast Wind hosted a voluntary informational drop-in session on June 27th, 2023 at the Somerset Public Library, where 7 South Coast Wind team members were available with project materials to answer questions and connect with the community members. The event was advertised in the Fall River Herald, the New Bedford Guide, and Facebook Live Fall River show, again, reaching out to Fall River, the environmental justice community. And then more recently, on July 12th, 2023, at the Council on Aging Center in Swansea, South Coast Wind gave a project presentation and took questions from over 70 community members. And I should mention, to Kelsey's credit, in July this year, South Coast sent an informational mailing to all Fall River households in the environmental justice communities within 1 mile of the project, totaling more than 10,500 households. The mailing, available in both English and Portuguese, included information on the South Coast Wind Project, planned activities on Brayton Point, and local economic opportunities. It also included a QR code for the project website, which is available in 12 different languages. And again, that is to Kelsey Perry's credit. Well done.
Ms. Freeman, is the letter that you just mentioned sent to the EJ communities, is that letter any place in the record?
This is Kelsey. It is not, but we can.
I think it would be helpful to have that letter in the record. I'm going to ask Mr. Brock what my next record request number is. I want to make sure we're on the same page. No pun intended. I think we're at 18, but
I think that's right, Mr. Shea.
okay.
18 is the next.
I'm sorry, 18?
18 is the next.
The next, okay. Yes, so RR EFSB-18, I'd like a copy of the letter that was just referred to, sent to the people in the EJ communities. And then let me ask you, how did you get, well, all right, that's 18. How did you get a list of addresses to send this letter to?
What we do, this is Kelsey speaking. What we do is we reach out to the city of Fall River and get a copy of all of the voters in Fall River with all of the mailing addresses. And one of our community liaison officers went through that list and sorted street by street based on the EJ map provided by the state. So we essentially just pared down the entire Fall River residency list to just include the households within the 1 mile of Brayton Point that are EJ populations.
Thank you. And I don't mean to be pedantic, but I do want to make a distinction. Based on what you're telling me, I believe that you sent a letter to all registered voters who live in the EJ communities and not necessarily all residents. Is that accurate?
That is accurate.
Okay. Now, Ms. Freeman, you were mentioning those hearings which are referenced in the cover letters, the FEIR. They're also mentioned in the FEIR 2-2, page 2-2. And they mentioned the Fairfield Inns meetings in Somerset.
I'm sorry, they mentioned the what?
I beg your pardon. The meetings at Fairfield Inns and Suites in Somerset, the Somerset Public Library, and the Council on Aging Center in Swansea. Are any of those locations located within an EJ community?
This is Kelsey. No, they are not within an EJ community.
Thank you. The FEIR 2-3 states that the company will coordinate with, quote, Sabrina Davis of Coalition for Social Justice regarding air emissions during the project. Has the company met or communicated with Ms. Davis already?
This is Kelsey. We have not.
Okay, how will the communication work? Under what circumstances will the company contact Ms. Davis?
Air emissions.
They, Ms. Davis, identified as the right contact person. We would meet with them, reach out to them.
Yeah, this is Kelsey. Ms. Davis was identified as the right contact person to reach out to regarding the EJ related matters in that section. So essentially we would try to reach out to her via email or call and touch base prior to construction.
Do you have her contact information?
I do not, or we do we have it from the state?
Yeah, this is Jamie Durham. We were provided with her information. Yes.
Yeah, you do have her contact information. Thank you. In the FEIR, attachment C to the FEIR, in the FEIR 2-3, you state, I'm going to quote, in response to the DEIR certificate, DEI certificate comments on the subject, South Coast Wind performed a supplemental, refined, and more detailed analysis of the projected air emissions from vehicular traffic during constructions. The comment that's referred to was a request in a certificate on the DEIR for, quote, a discussion of why the estimated air emissions for the project are so high when compared to other similar projects, close quotes. So my question is, did the refined and more detailed analysis start from the presumption that the information provided in the DEIR was somehow insufficient or inaccurate?
I'm just finding the section. This is Kathleen Freeman. In short, it wasn't inaccurate. It was overly conservative because it was based on COP emissions. I'm speaking at the top of my head and I'm just trying to find the exact location. What our air subject matter experts did was they took the our projected construction schedule and durations, and they recalculated the emissions, and the refined information is provided in, I believe it's section 4.
Yeah, it's in, okay.
Not 4, Jamie.
Section 2, right?
Yeah, it would be in
Justice and Public
2,
Health.
yeah. Hang on.
So the revised analysis was done because well, you say the COP used very conservative emissions. I'll say at FEIR 2-4, it states that, quote, the COP used a very conservative emissions estimate, and in parentheses, BOEM, B-O-E-M, offshore wind energy facilities emission estimating tool 2017, close quotes.
Yes, I found where you're reading, and based on the DEIR certificate inquiry, these onshore emissions have been reviewed and refined to reduce the level of conservatism built into the COP estimates. And upon refinement, South Coast Wind believes that the emissions previously provided are more in line with the typical anticipated construction emissions. The majority of particulate matter emissions previously estimated were from fugitive dust during construction. Updated estimated emissions of fugitive dust are based on the most recent construction schedule and acreage for the planned construction of the converter station and cable installation on Brayton Point. And the majority of carbon monoxide emissions were from the construction generators, for which construction schedule requirements have reduced the projected emissions significantly. And for these reasons, vehicular emissions associated with the project are not likely to materially exacerbate existing public health conditions in the identified environmental justice populations. And I mean, we were very mindful of the revision, the MEPA revisions to their regulations as they pertain to environmental justice populations, those revisions that were made in January 2023. And again, we sharpened our pencils to get an estimate that is more reflective of projected construction activities at Brayton Point.
So the concern, I understand what you did. My question is about the factual basis for decide, and you went over this to some extent, but I just want to pinpoint this. The factual basis for deciding that the BOEM offshore wind energy facilities estimating tool 27, that that tool was too conservative. And you mentioned fugitive dust. Is that correct?
Yes.
Okay, so the BOEM estimating tool was not accurate because it overestimated the amount of fugitive dust that would be at the in the EJ area.
Yes. For the initial DEIR, we took readily available information from the COP air emission estimates, and based on our discussions with the MEPA director, who said we do not have to, given we're a renewable energy project, we don't have to do a mesoscale analysis that other development project, like a manufacturing facility or a scrap metal operation, would be required to do. She counseled us or directed us, we could use existing information that's already in the COP and try to adjust it to what we would project would occur in the Brayton Point area, which is what we did. And in doing that, we were overly conservative, which is what the COP emissions are intended to do. The COP analyses are intended to look at worst case scenario, and they include a larger area than what we presented in the DEIR. And when we looked at the actual acreage and the types of the period of construction and the duration of construction at Brayton Point, the values came down dramatically, as you can see in the tables and the attachment that we provided, which goes into more detail of the analysis that was presented by our air emissions subject matter experts at AECOM.
Ms. Freeman, you said we don't have to do a mesoscale analysis.
Mesoscale, MESOCALE, mesoscale analysis.
Thank you.
It's important to stress that we are not a Massachusetts stationary source, unlike a manufacturing facility or a let's say a scrap metal operation. The emissions we will have will be temporary and localized and come from construction. Once construction is complete, there will be essentially no emissions. We will be an unmanned substation. So there's no operational analysis necessary because it's just going to be a substation. There will be no air emissions such as particulate matter from our operations, only during construction, during a temporary period, and those emissions will be managed through avoidance and minimization measures, best management practices. So we expect that any emissions during our construction activities will be minimal at best and not have a disproportionate adverse effect on environmental justice communities or the communities in general.
I'm going to ask you to define mesoscale. I think that's the word you used.
Jamie, you want to take?
I can take a minute. That'd be great.
Okay, we'll get back to you on that. It's a term that's used typically for stationary sources, manufacturing facilities, to really dig in on the emissions. In the MEPA greenhouse gas policy, there's an exception for projects such as ours, an offshore wind project that will have substantial greenhouse gas reduction measures or results.
Okay. Now you say there's this exception. Where's the exception?
It's in the MEPA greenhouse gas policy. I believe it's dated back to, was it 2010? I can find that language if you give me a few minutes.
Yeah, this is, get back on. This is Jamie Duran from Power Engineers.
Sorry. Yeah.
So looking back at the division of Department of Environmental Protection, air quality regs, mesoscale is basically an analysis of indirect source or an estimate of the mobile source emissions generated by the project, like as compared to an area-wide or regional emissions from the existing environment.
Mr. Duran, which regulation is that you're reading from?
I'm looking at the Department of Environmental Protection guidelines for performing mesoscale analysis of indirect sources.
But is there any citation to a CMR reference? CMR stands for Code of Massachusetts Regulations.
I'm looking right now.
And Mr. Shea, when you're ready, I have the MEPA citation.
Great. All right, why don't you give me the MEPA citation when Mr. Duran is looking?
Okay, it's the revised MEPA greenhouse gas emission policy and protocol, effective date May 5th, 2010. And the provision, it allows for projects such as ours to opt out. It says the secretary will consider on a case-by-case basis, allowing proponents that commit in advance to exceptional greenhouse gas reduction measures to opt out of the quantification analysis. The rationale for the opt-out provision is that if proponent commits to such extraordinary measures like ours, which is over 2 million, reduction of 2 million metric tons of greenhouse gas a year, then these projects are treated differently than your regular project. And the examples of projects include generation of renewable energy, e.g. a wind farm or large-scale solar installation.
You talked earlier, Ms. Freeman, about talking to someone at MEPA who told you various things about making the estimate. Who was that person?
That would be the director, Tori.
Tori Kim?
Yes.
Thank you. Now, I'm a little confused. The company seems to have changed its way of estimating the emissions from using the BOEM and the COP use to something else, the more refined analysis. Was this change made due to the MEPA revised greenhouse gas policy of May 5th, 2010, or was it made because the BOEM offshore wind energy facilities estimating tool was inaccurate?
Kathleen Freeman, it's because it was done at the request of the MEPA office to provide a more refined analysis. Because the emission levels taken from BOEM looked unusually high, and MEPA was correct. They were high because they were very conservative, included a large aerial area, which is explained in more detail in the attachment provided by AECOM. So it wasn't because it was inaccurate, it's because the model that was used for BOEM is, and maybe Jen, correct me if I'm wrong, is overly conservative and intended to estimate worst case scenario. And what we did was, at the request of MEPA, to really dig in and try to bring that over-inclusive analysis down to our level and reality, and what will actually happen at Brayton Point with our project. And again, those emissions are still conservative because they do not reflect our our emission control measures for avoiding and minimizing emissions through best management practices, which are detailed in our DEIR and FEIR, including wetting down soils, covering soil piles, many measures that will substantially reduce those estimated values.
Thank you. You referred to AECOM. The analysis attached to the FEIR was performed by, then I'm going to spell this out, all caps, A is in Arthur, E is in Edward, C is in Charlie, O is in Oscar, M is in Martin, AECOM.
That is correct, Kathleen.
Right. Who are they? I didn't see anything about, is it a corporation, an LLP, a partnership? Are they scientists, engineers? What can you tell me about AECOM?
This is Kelly Smith. I used to work for AECOM early in my career, so I can speak to that.
I'm sorry, can't hear you.
This is Kelly Smith for the company. Early in my career, I worked at AECOM, so I can take that question. They're a very large publicly traded level engineering and consulting company with many areas of competency in infrastructure and analysis.
They're large, they're publicly traded, and did you say engineering? That they're basically engineering analysis?
Engineering and consulting through to construction as well. They do EP.
I'm sorry, engineering and construction, what?
Through to engineering and consulting through to construction as well.
Okay.
Kathleen Freeman, can I add to that? They include scientists, engineers, and they were one of the major environmental consultant firms that helped prepare the BOEM construction and operations plan COP. So we work with them closely on another on the Falmouth project, but they were very much involved with the air emissions analyses performed for the COP, and they assisted in the analyses for both the DEIR and the FEIR.
Okay, I see that in Exhibit C to the FEIR, this Exhibit C was prepared by two people, one named Wes Baggett with 2 G's and 2 T's, and Kevin Voigt. Yes. Do you know what their qualifications are?
Not off the top of my head, but I know Kevin Voigt has been involved, and they have involved with the air emissions analysis that was done for the COP, and that was done for both the analyses for the DEIR and the FEIR.
Thank you.
I can, if you give me a minute, I'll find that.
Their qualifications? Okay. Was I waiting on something from Mr. Duran?
Mr. Duran just stepped away for a moment. He'll be joining us in a minute.
This is Jennifer Flood. I can just add that Kevin Voigt is the manager of the AECOM Air Permitting and Compliance Services Division.
Okay.
Thank you.
My memory is that Mr. Duran was going to get back to me on something, and it just slips my mind what that is.
This is Sly Smith. Was it the definition?
I'm sorry, just can't hear you, Ms. Smith.
Sorry, the speaker situation is different today. Was it the definition of mesoscale, which I believe he provided?
Yes, and Mr. Duran defined mesoscale, and he quoted from some regulations, but he didn't have the citation, the CMR citation. As I mentioned, CMR is Code of Massachusetts Regulations. So, well, when he gets back, if he has that information, I would find it useful.
Mr. Shea.
Mr. Shea, this is Jamie Duran from Power Engineers. So,
Mr. Duran, how are you today? Good.
I'm doing well. So the definition and the explanation I was giving for mesoscale analysis is from a DEP guideline that it's not tied to a specific regulation. It's more of a guideline on how to do mesoscale analysis. But this wraps back to the NEPA regulations at 301 CMR 11 and the greenhouse gas emission policy.
Okay, so you say it's linked back to NEPA regulations. The first one was 301 CMR 11.
Correct.
And what was the second one that you said?
One is the DEP, the Massachusetts Department of Environmental Protection, guidelines for performing mesoscale analysis of indirect sources.
Okay,
Mr. Shea?
yes, sir.
Yeah, Eric Runge speaking. There is also something called the MEPA Greenhouse Gas Emissions Policy and Protocol. And I think that is relevant to your inquiry.
That's
Thank
the,
you.
this is Kathleen Freeman. That's the protocol, the greenhouse gas protocol that I referenced earlier, Mr. Shea.
Now, my understanding is that after these revisions were made, the air impacts on the environmental justice communities was substantially less than before these revisions were made. Is that correct?
Kathleen Freeman, yes.
Okay. Is there any table in the record that compares the air impacts projected in the DEIR to the air impacts projected in the FEIR?
No. That's Kathleen. No, we can certainly provide a table if that would be helpful.
It would for me, yes. I think that would be helpful to address EEI in addressing the environmental justice issues. So I'll ask you a record request for that. That'll be 19 RR-EFSB -19, and that would be a table comparing air impacts in DEIR on EJ populations to air impacts in FEIR on EJ populations. Thank you. I'm going to switch gears here, and I'd like to address the issue of employment opportunities for EJ and tribal populations that may be created by the project. In the analysis at section 5.4.3, which is at page 5-42 and 5-43, it states that the company is working to, quote, provide local Native American communities with cost-free training and all certifications required to work as protected species observer, close quotes. Now, does the company have an arrangement with any particular Native American tribe regarding this training?
This is Kelsey. There is no arrangement with any certain tribe. The program is open to any tribal member that's interested, and both federal and state recognized tribes are welcome.
Has any notification been sent to the federal and state recognized tribes regarding this possibility, this opportunity?
We have, this is Kelsey again, we have shared this opportunity through, mainly through our tribal contacts with these various tribes that we've been working with on other related matters, and through advertising the program in the last year and a half, we have been able to meet more tribal members and work with our graduates of the program to spread information about the opportunity, but no formal notification has been mailed.
So you say you work with tribal member contacts.
Yes.
And which tribes do they represent?
The Mashpee Wampanoag tribe, the Narragansett tribe, the Pecasset tribe of both Massachusetts and Rhode Island, and the Aquinnah tribe on Martha's Vineyard.
Thank you. Who provides this training?
This is Kelsey again. RPS, the group that we mentioned earlier, provides the training. The training does happen locally. We have had 2 rounds of the training so far that have both taken place at the Fall River office, 99 South Main Street, where RPS flies in a trainer for a week to train the tribal participants.
is there any, this protected species observer qualification, is there any state, local, or federal government or independent body that certifies such a status, PSO status?
This is Jennifer Flood. The National Marine Fisheries Service has to review and approve the protected species observers before they go out on site characterization vessels.
Okay, that's good. That leads into my next question. In response to information request EFSB-EJ-3, it states that 3 Native American participants have completed the PSO training program and have been deployed at least once as paid PSOs on survey vessels for the offshore wind industry. So the program that these individuals participated in was approved by was it approved by the National Marine Fisheries Council?
This is Jennifer Flood. Them as certified protected species observers was approved and they were able to go out.
Very good. And I get the impression from the answer that protected species observers are independent contractors. Is that correct?
They typically are, this is Jennifer Flood, they are typically the 3 that we have put through our training program so far have worked for RPS, who have been subcontractors to our survey vessel suppliers.
And do you know if they're independent contractors to RPS or whether they're employed by RPS?
I do not know.
In another part of the analysis, section 5.4.3.1.1, that's on page 5-43. It states that the company is committed to making at least 75% of operations and maintenance jobs local. And this is repeated again in the DEIR. So in response to another information request, EFSB-EJ-2, the company states that that it is committed to the 75% number, and quote, as the project progresses, it will sign contracts with suppliers. We will seek to include that commitment in those contracts and require potential suppliers to include a plan on how they would meet the necessary obligations. To whom are you referring to whom is the company referring when it uses the word suppliers? Suppliers of the turbines, the general contractors, the subcontractors?
This is Kelsey. Yes, that's correct. It's referring to, I believe, our tier 1 suppliers, which are our main contracts for the turbines, cables. There are 6 major packages with the project.
Let me ask you, is there a general contractor in this for this project?
This is Kelsey. No, there's not.
Okay, and instead you say there are 6 major, explain it, 6 major, I forget the noun.
Packages.
What is
6
that?
6 major packages. Tell me about the 6 major packages.
This is Tim Ryer speaking, so I can explain a bit, and I apologize if I miscount anything. But essentially, with SouthCoast Wind acting as the owners team, with a team of engineers, project managers who are.
I beg your pardon. With SouthCoast Wind acting as the, and I didn't catch that word.
Owners team.
I'm sorry. Now I didn't hear you. We're talking over each other, and I didn't catch that word.
This is Tim Ryer speaking again. So with SouthCoast Wind acting as the owners team, the contracting of the work would be subdivided into what we're calling packages that are sort of logical splits of the work based on how the different aspects of the work interface with each other. So for example, turbine supply, turbine installation, the foundations for the turbines, export cables, inter-array cables.
I'm sorry, export cables, what?
Inter-array cables, which connect the turbines to each other and transmit power between turbines. Just listing off a few examples here, this might not be comprehensive. But just to give a flavor of, how we divide the work and how those works might be done by different contractors or suppliers based on their given specialization and capabilities, as the different aspects of the work require different specializations and different manufacturing capabilities, with the ultimate integrator of that work being the owner of South Coast Wind, as we're managing the project.
You said at the beginning, thank you for the answer. You said at the beginning, with South Coast Wind acting as the, I think, overseer, was that the word you used?
Owner's team, OWNER, owner.
OWNER, the owner?
Yeah.
The owner's, but did you have the word steam after that?
Owner's team.
The owner's team.
Yeah.
Okay.
We can just call it the owner. How about
Yeah,
that?
that's it.
No, that, because owner's team, I heard it as overseer, but thank you. So there are 6 packages, as you mentioned. Obviously, some of these packages will require qualified people who have qualifications, maybe particular licenses, a hoisting license or an electrician's license. Do you understand? You understand what I'm saying?
That's correct. Yes. For certain specialized aspects of the work, one or multiple qualifications would be required. That's correct.
Now, will there be sufficient numbers of union members, or not, I say union members, I say union because a lot of this work, in my experience, is union, but will there be sufficient numbers of people who are qualified to do the work in the local area to reach the 75% number?
This is Tim Ryer. I'll speak in general. So maybe to clarify, the 75% number that's referred to is 75% of operations and maintenance jobs, and to distinguish between the work packages that Kelsey was referring to and the operations and maintenance jobs. So once the facility is installed, commissioned, and operational, that's what we would typically refer to as the operations and maintenance phase. So those post construction and post commissioning of the facility would be what we refer to as the operations and maintenance jobs. And prior to the commissioning of the facility and the works to install transport goods, manufacture goods, would be typically what we were referring to more as the sort of EPCI owner's package. So
I'm sorry, EPCI owner's package.
Sorry. This is more of what we would refer to as sort of those separate packages that I was referring to, the split of the individual contracts with the different specializations, and our the way that we would manage the operations and maintenance jobs maybe just look slightly different based on the capabilities and specializations required to maintain a wind farm rather than to construct a wind farm, for example. So I don't know if any of the other colleagues would want to comment on, specific workforce issues, but I just kind of clarifying that point about operations and maintenance commitments versus construction commitments.
Thank you. That's very helpful. Does anyone else want to comment? Any of the other witnesses? Now, the operation and maintenance jobs, do you anticipate that a percentage of those operations and maintenance jobs will require specific talents or licenses, such as an electrician's license, a hoisting license, that sort of thing?
This is Tim Ryer again. Yes, in general, some of the jobs will require specializations and licensure. So
is a 75%, given that a certain percent will of these jobs will require certain specializations and licensures, do you anticipate finding the qualified people in the EJ area?
This is Kelsey. I mean, we hope that some of these personnel would be coming from the EJ area, especially in Fall River and New Bedford. We are working to invest in training programs now in hopes that local people are able to gain all the certifications required to be able to participate when we have these jobs available. For example, I believe in our information request, we mentioned our investment to NAUI or Bristol Community College, their National Offshore Wind Institute, where they will be training local people to be qualified to be able to work these jobs. So we hope that through outreach and investment in training that folks in EJ populations will be able to participate, and we're working towards that.
Thank you. I'll switch now the DEIR to another subject. The DEIR at section 5.2.5 states that pursuant to an act relative to the licensing requirements for certain tide lands, the Secretary of EEA is required to conduct a public benefit review of certain projects in tide lands and make a written determination as to whether the project's benefits outweigh any potential detriments. And there's a site there to 301 CMR 13. My question is, has the Secretary issued a public benefit determination regarding this project?
Mr. Shea?
Yes, sir.
Just trying to get back onto the screen here, but this is Jamie Duran from Power Engineers. So Secretary has not yet made that determination. It's understanding that through the FEIR process that the Secretary would make such a determination. And then we anticipate then filing our Chapter 91 waterways application with the Department of Environmental Protection Waterways Division.
Okay, so until a public benefit determination has been made, then you can't file a Chapter 91 application?
Nope. We are planning on submitting our application. Well, so the answer is no to your question. We can submit the Chapter 91 application prior to the Secretary's decision.
Okay.
But Chapter 91 folks would not make that final decision and issue our license until they have the Secretary's decision, including the public benefit determination.
Mr. Shea, Kathleen Freeman, we have intentionally held off the filing of our Chapter 9, our joint application for a Chapter 91 waterways license and water quality certification until conclusion of the MEPA process. But the public benefit determination standards at 301 CMR 13.04 indicate that the Secretary, the EEA Secretary, shall presume that water dependent projects such as ours meet the criteria listed in the regulations and provide adequate public benefit, as the Secretary has done for other offshore wind projects.
Should I ask for a copy of that public benefit determination when it's rendered?
Yes, of course. Is that a record request?
No.
Yes, that'll be RR-EFSB-20, and that would be a copy of the public benefit determination.
Okay. So the request would be when it's available.
When it's available, yeah.
Yeah.
It would hardly be reasonable for me to ask you for that document before it becomes available. But yes, thank you very much. I appreciate that. I'd like to next go to the ocean development mitigation fee. In the DEIR at section 5.3.5.1, the company proposes a base ocean development mitigation fee of $131,233. But the FEIR at 3-1 states that the Massachusetts Coastal Zone Management Office has determined that the project won't be located in a OMP area, and therefore no OMP fee would be required. My question to you is the coastal zone management determination the final word in this project, in this process, excuse me?
Mr. Shea, this is Jamie Durand. Yes, and as we stated in section 3 of the FEIR under the Ocean Management Plan, again, reiterate that however, per DER comments from CZM,
I'm sorry, just can't hear you.
Okay.
We reiterate that.
From the section 3 of the Ocean Management Plan, section 3 of the FEIR, comments from the Mass CZM indicate that the CZM determination that the project is not located in an ocean management plan area indicates that an OMP Ocean Management Plan fee is not required.
A question, I saw that, and do you know whether the CZM comment is the last word on the subject, or does someone else get to weigh in on this?
This is Kathleen Freeman. I'm not sure what the answer is on that. We are still proceeding through our MEPA process, and as you know, the MEPA process is to instruct the permit writers on what to include in their permit requirements. So I am reluctant to speculate on that question.
What other documents do you expect to get from MEPA?
From MEPA, Kathleen Freeman, from MEPA, the Secretary's certificate on the final environmental impact report we filed last Friday. There is a review process. There will be further comments, but to conclude the MEPA review process, it would be the certificate of the EEA Secretary providing guidance to the permit writers.
Do you know whether the company is already obligated to produce that document?
Mr. Shea, do you mean obligated in this proceeding or somewhere?
Yes, obligated in this proceeding to produce it.
Yeah, we have certainly provided all of the materials related to MEPA in this docket. We would certainly provide that as well once it becomes available.
Okay, that'll be very helpful. I appreciate that.
Mr. Shea, this is Kathleen Freeman. We expect that the FEIR will be published in the Environmental Monitor
August 9th.
August 9th, and then it will go through the public review process. I believe in total it takes about 45 days approximately,
Right.
before a certificate will be issued. And prior to that issuance, we imagine we will have discussions with the MEPA office.
So do you anticipate then that the certificate will be issued sometime in late September or early October?
That sounds about right.
September 15th.
September 15th? Okay, thank you, Jamie.
I'd like to go now to the issue of reliability. The DEIR at section 5.2.3 addresses the reliability benefits of the project. And that's also addressed in section 1.5.2 of the analysis. Does the intermittent nature of wind power affect these reliability arguments?
This is Kelly Smith speaking for the company. Offshore wind power actually has a relatively high capacity factor. I want to say it's around 50% or so. My colleague Lawrence Mott could speak to it a bit better.
I'm sorry, my colleague, what?
Lawrence Mott could speak to it a bit better, but he's not on today with us. But when you compare that to renewable sources like solar, it is much more reliable. And particularly during the winter months when the New England region is constrained due to the natural gas supply. So it is a reliable resource. And it also compares well to conventional fossil fuel and nuclear generation in terms of its capacity factor.
That's a good point. The capacity factor for the wind farm, you say, is roughly about 50%. Is that correct?
That's correct.
What is the capacity factor for, let's say, nuclear power?
We might have to get back to you on that unless someone else in the room has that figure handy. I think we can answer either after the break or in a few minutes.
Okay, and then I'd be interested in the an average general capacity factor for nuclear and for natural gas.
Mr. Shea,
Yes, sir.
sounds like you're interested in a comparison against baseline generation, but I think one of the points that the company has made is that we're comparing it also against other intermittent resources, which will be predominating on the system in future years, and compared to solar, I think is a key comparison point.
Yes, that's a good point. You do compare wind to solar, but while the wind solar comparison is useful, the wind baseline comparison would be useful when you take into account the load and the demands of the load. So I think that if you can you get back to me after a break on the capacity factors with respect to nuclear and natural gas?
We will try to do that, sir.
Okay, thank you. Speaking of breaks, I've gone for an hour and 16 minutes. Mr. Brock, would you like a break?
Whenever you would like, I'm fine with going longer or not.
Well, why don't we go for a few minutes then? I mean, we usually take a morning break, and then we usually break at lunch. But actually, this is a good time to break because my next questions are all about zoning. So let's take a 15-minute break. It's 11:16. Can I see you all back here at 11:31?
Okay.
Thank you very much. I appreciate it.
You. Can somebody make it so, please? Okay. Don't they do that in Coast Guard too? Make it so. Star Trek.
Apologies.
No apologies necessary. 30-second delay is hardly anything to worry about. I'm going to wait though till Mr. Pucci and Ms. Gabriel get on there. And Ms. Devaka.
I apologize. I didn't realize I wasn't on camera.
Oh, don't worry.
Sorry.
No problem.
I'm here.
No problem. Thank
Sorry.
you.
I think we can proceed. I mean, Ms. Sefiel's probably on, and if not, I'm here. So.
Okay. Back on the record. I'd like to ask some questions now about zoning.
Mr. Shea, did you want to follow up on your previous question? I think you were asking about capacity factor or something.
Yes, someone was going to get back to me after the break about capacity factors.
Yes, this is Kelly Smith talking. I can take that. So we did some quick searches of reference capacity factors for comparison. Nuclear is among the highest capacity factors, running on the order of 86%. That's the type of facility that's more efficient to run constantly as baseload power. Natural gas comes in around 57 to 60%. But with the states and regions renewable energy targets, there will be a shift towards more intermittent resources, and natural gas will function in more of a peaking capacity. And then offshore wind, as we mentioned, is around 50%. So the most reliable for intermittent sources. In Massachusetts, solar capacity factors are around 18%. Wind in Massachusetts is around 28%. And onshore wind, speaking specifically, and onshore wind would be a bit higher further north in Maine, for example.
I'm sorry, and what? And offshore or onshore?
Onshore.
What was the figure for onshore wind?
Onshore wind in Massachusetts, around 28%. Further north in Maine, around 38%.
All right, that's very helpful. Thank you. Now, and thank you for reminding me, Mr. Runch. I wanted to, on zoning questions, I'm looking at the response to information request EFSB-Z-5D, which states, the response states that the company would not object to reasonable grading and drainage requirements. And I believe the company suggests that reasonable requirements should be limited to the stormwater, the stormwater handbook. And there's a reference that the Mass DEP has incorporated the stormwater management standards into the Wetlands Protection Act regulations and the Water Quality Certificate regulations. I just want to get a better sense of what the company is proposing. Does the company not object to a condition that complies with those specific regulations? Or does the company not object to a condition that applies to the general stormwater handbook standards?
Quick clarification.
This is Kelly Smith speaking for the company. I'm a little unclear on the distinction. If you wouldn't mind repeating the question.
Sure. I'm looking at the response to EFSB-Z-5. And it states the company does not object to the siting board establishing as a condition of its decision a reasonable grading and draining requirement for the converter station, and respectfully suggests that the requirement be that the company meet the applicable requirements set forth in the Massachusetts Stormwater Handbook and Stormwater Standards. I guess my first question would be, where would I find the Massachusetts Stormwater Handbook and Stormwater Standards?
Yeah, I'm gonna follow up.
Just give us a minute here, Mr. Shea, and we'll.
Oh, of course, of course.
It's available through the Mass DEP. This is Kelly Smith speaking.
The Mass DEP website.
Correct.
Yes.
In order to make it part of the record, though, I'd like to ask it. I mean, I could find it myself, but what I find isn't necessarily part of the record. So could I ask a record request that you produced that document? It would be record request RR-EFSB-21, and that's the Massachusetts Stormwater Handbook and Stormwater Standards.
Yes, we can provide that.
Thank you, I appreciate that. There's a reference in the record that the Massachusetts DEP has incorporated some of these standards into regulations issued pursuant to the Wetland Protections Act and the Water Quality Certification Act. And I get, my question is, what exactly does the company not object to? Does it not object to a condition that's based on the handbook, the Massachusetts Stormwater Handbook, or does it not object to a condition that's based on the regulations that are cited? I should give you the regulations. The Wetlands Protection Act regulations are 310 CMR 10.5, paren 6, paren B, paren 1, paren A. And the Water Quality Certification regulations are 314 CMR 9.06, paren 1, paren A. So I guess my question is, when the answer to this information request says the company does not object to the siting board establishing as a condition compliance with the Massachusetts Stormwater Handbook and Standards, is it referring just to the standards, or is it referring to the regulations that I referred to?
This is Ms. Smith talking for the company. We don't object to the handbook or the regulations. I think the distinction that was intended to be made with this response to the information request was any additional requirements associated with the zoning bylaws in addition to the state level requirements.
Okay, because this is in the EFSB-Z-5 was regarding the exemption from section 6.10.1 of the Somerset zoning bylaw. And
I believe that ties to an approval process with the Somerset Board of Appeals.
right, and there's reference to zoning to grading requirements. So the answer is that you don't object to a condition that is consistent with the stormwater handbook or the regulations?
At the state level, correct?
Thank you. I'm gonna refer to response to EFSB-Z-1 at 3.
I'm sorry, EFSB's
Sorry.
Z
Z is in zoning, excuse me.
one, what?
Z-1 at page 3,
Okay, thank you.
excuse me.
Okay, I believe we're there.
Okay, that response states that South Coast Wind will revise its operational noise modeling report to see if the 55 decibel thresholds can be achieved with reasonable mitigation techniques. And then a later response to EFSB-Z-15 states that the company can comply to the 55 decibel threshold for residential boundaries. So now that the record has established that the company complied with this threshold, does that compliance eliminate the need for an exemption from the zoning noise bylaw, section 6.9? And I can read the zoning noise bylaw too, if you don't have it.
This is Ms. Smith. So I believe it would mean that we'll meet the requirements as they're currently written in the bylaw for the
Wait, sorry,
55
meet the requirements as they're currently,
as they're currently established in the bylaw.
So if the company can meet the requirements as they're currently established, is an exemption from this section required?
This is Gemma Cashman. To clarify, we're speaking about the separate noise bylaw that is not part of the Somerset zoning bylaw.
I thought that's a good question. I thought section 6.9 was part of the Somerset zoning bylaw.
That is correct. But the
Okay.
reference to compliance with the 55,
I'm sorry, that is correct. And then you dropped out.
that is correct. Speaking to the compliance with the 55 dBA requirement, that is set forth in the separate Somerset noise bylaw.
Okay, that's a good distinction. Thank you. I understand that the town has a separate noise control bylaw which governs noise, but is not a zoning bylaw. And is that my understanding correct?
Correct.
I'm
Now,
sorry, was that Ms. Cashman?
Yes, Gemma Cashman.
Thanks.
In this proceeding, does the company request an exemption from the town's noise control bylaw as distinct from any provision of the zoning control bylaw?
For clarification, we are asking for an exemption from section 6.9 of the zoning bylaw, not an exemption from the separate Somerset noise bylaw.
And is there any request for an exemption from the noise control bylaw?
No.
Thank you. And the 55 dB figure, do I understand your testimony to be that the 55 dB figure is in the noise control bylaw, not the zoning bylaw?
Gemma Cashman, correct.
Okay. Can you tell me how loud a 55 dB sound is? How would it compare to, for example, the sound of a refrigerator in the same room as a listener?
We might need a moment to pull up the operational noise report.
Thank you. Sure.
We don't have this with us at the moment.
Thank you.
Just know that you know. Mr. Shea, I think we have also asked Ms. Wood, who was a witness earlier in the hearing, to see if she can join us. We're not sure if she's able to right at the moment, so wonder if Ms. Smith's not able to pull it up soon, would you like to ask another question while we wait?
This is Ms. Smith. I did actually find the reference. So in the revised operational noise report, which we submitted as part of our response to SOM-8,
Okay.
there is a table 1 on page 3 of the report that provides typical range of audible noise from various sources. And in the range of 50 to 60 dBA, the listed example is a typical business office.
That's helpful. Thank you. I'm going to address your attention to the testimony of Tim Turner, which was submitted by the town of Somerset. And there's a letter from the Somerset ZBA to the town administrator attached as Exhibit A. In that letter, the zoning board of appeals states that the company has made no effort to clarify requirements under the town bylaws with the Somerset ZBA. That's in the letter attached to the Exhibit A, and it's in Mr. Turner's affidavit. How does the company respond to that claim?
This is Ms. Smith. We responded to that letter in our response to EFSB-Z-17.
EFSB-Z-17?
That's correct.
Okay, thank you. And can you just paraphrase what that response is?
Yes, I'll need a moment to get there. So I'll read a portion of the information request, rather. So for part A of the query was for the company to provide a response to the comments and arguments in the letter. We disagree with Chairman Carteret, thank you. Mischaracterization of SouthCoast Wind's engagement with the town of Somerset. SouthCoast Wind has engaged and will continue to engage diligently and in good faith with the town regarding.
I'm sorry, I'm having difficulty here. SouthCoast Wind has engaged and
will continue to engage diligently and in good faith with the town regarding the project. SouthCoast Wind intends to comply with all applicable zoning requirements to the extent practicable as it designs, constructs, and operates the project. To date, at the town administrator's request, the company has engaged directly with the town administrator on matters of interest to the town. The company is ready, willing, and able to engage informally with the zoning board and planning board to receive input and discuss compliance with applicable town requirements. Per the direction the company has received from the town, those discussions should come through the town administrator.
So when the zoning board of appeals says, in essence, you didn't contact us, that allegation may be true, but the company didn't contact the ZBA upon the direction of the town. Is that correct?
That's correct.
Okay. I want to take you through the letter of May 1, 2023 from the Somerset ZBA to the town. The section 2A of the letter states that pursuant to provision 4.1.4 of the bylaws, it's evident that a converter station is substantially similar to two similar authorized uses and therefore does not appear to be prohibited. How does the company respond to that?
This is Gemma Cashman. I can speak to that for clarification purposes if it's helpful. We did respond to EFSB Z3, which addresses the similarity between the converter station use and the uses provided in the use table. But in summary, our position is that it is ambiguous whether or not the company's proposed use falls within the terms of the allowed use, because it is not specifically defined in the zoning bylaw, and that creates risk for.
I'm sorry, it's not specifically defined in the zoning bylaw, what?
Which creates risk in disputes or third-party appeals of a zoning determination.
Okay, this is a good, you're a good person to answer the question. Why is substantially similar? Why is that important? That is, can you tell us about the doctrine of substantially similar uses?
Yes, this is Gemma Cashman. There is established Massachusetts case law that we included in our response to information request EFSB Z3, where a bylaw does not specifically define a term. It's derived from the word's usual meaning. And here the terms transformer station and electronic substation are not commonly found in the legal context or in dictionaries. And their substations generally are comprised of highly specialized electrical equipment. So again, it's ambiguous whether or not the use falls within that definition in the zoning bylaw, and again, creates risk that the zoning bylaw could be construed or represented as incompatible with aspects of the project, which could result in disputes, third-party appeals, which would in turn cause delay.
So if I understand you correctly, substantially similar, that term is a bit subjective. Is that correct?
That is correct.
And the subjectivity creates a risk.
That is correct.
Thank you. Now, provision 4.1.4 of the letter requires that an entity proposing a similar use obtain a special permit pursuant to section 7.5 of the bylaws. Tell me about obtaining a special permit. Would that be possible for the company?
This is Gemma Cashman. Speaking to the standard of a special permit standard of review is seen as disfavored because it opens up the company to subjective conditions that could be imposed by the board, even if it is approved. And then in turn, those approvals could be appealed by third parties, which would in turn cause delay for the company.
Okay, in section 2, thank you for the answer. In section 2B, the letter asserts that exemption from the setback requirement, quote, is based solely upon speculation. And further, quote, close quotes, further, the letter states that this is due to the company's failure to reach out to the board. So how would you respond, close quotes, how would you respond to that?
This is Ms. Smith speaking, apologies. So specifically, I think we spoke in earlier days of testimony about the fact that the design for the converter station is at a 30% level. So there will be additional work to fine tune the layout of the equipment and the exact boundary of the fence line within our designated 10-acre parcel at Brayton Point. But as that design matures, it will be important for us to maintain required safety clearances and to maintain access points and access routes throughout the converter station. And so it is possible that with the detailed design of all the components, that the converter station fence line will not be able to have designated setbacks at the discretion of the zoning board from our lease line boundary. And I think we touched upon the point earlier regarding our failure to consult with the board and how that was done as a result of funneling communication through the town administrator at the town's request.
Thank you. The same letter at section 2D claims that there's nothing ambiguous about section 6.7 of the bylaw. And this letter at that point strongly implies the company is being perhaps a bit disingenuous about its need for an exemption. They don't use that word, but that's my reading of it. Can you respond to that, please?
Specifically on the matter of parking and loading,
Yes.
I do believe that we will have sufficient space available to include a few dedicated parking spaces. However, those are going to be internal to the converter station site. And as we spoke previously, it's an generally unmanned facility. And so that fence line will be safely secured, and it's not as if those parking spots would be used by general visitors. So we do believe we can maintain space for a few parking spaces, but it doesn't seem particularly applicable to need parking for a facility of this type.
Okay, so you think that the parking requirement, because it's an unattended, I'm not going to say unmanned, but unattended facility, the parking requirement is really irrelevant.
That's correct.
Okay, because the letter here talks about, the zoning requirement is 1 space per 1,000 square feet of gross floor area, and with parking, and says there's nothing ambiguous about the requirement. I guess my understanding is, even if there's nothing ambiguous about the requirement, an exemption is still appropriate. Is that correct?
That's correct. And I would say that this is one of the categories in which I think as we get further down the detailed design, we'll continue to have discussions with the right people at the town to establish what's really needed or appropriate here. And there's probably space available, but it's not a clearly relevant requirement for an unmanned converter station.
Okay. Now, in the letter at 2 print E states that the Somerset zoning bylaw refers to instances where excessive noise is not allowed in zoning districts, but the issue is more effectively governed by the town's noise control bylaw, and that this bylaw cannot be circumvented by the applicant's Chapter 48, Section 3 petition. I think I know what your response is, but I would like it for the record.
This is this is Kelly Smith. We do intend to hit the 55 decibel threshold. And as you'll note, the 55 decibel threshold is not cited in the letter. And I guess I would just highlight that that's been another point of ambiguity. When SouthCoast Wind initially submitted our operational noise report, we did interpret the noise standard to apply at the 70 decibel level. But in further discussion and consultation with the town, our understanding was revised to be that they intended it to apply at the 55 decibel level, which then catalyzed our update of the operational noise report to indicate that we would endeavor to do so, and have shown now that we're able to do so. So I guess I would just note that we intend to comply, but this has actually been another point of ambiguity as well.
Thank you for that answer. One statement in this letter, I think is, it's stated as an argument, but I don't think the company will disagree with it. And that statement is, quote, "This bylaw," the noise control bylaw, "cannot be circumvented by the applicant's Chapter 48, Section 3 petition," close quotes. I don't believe that is my understanding correct that the applicant's 48 Section 3 petition is
I'm sorry, is my understanding correct?
That the applicant's Chapter 48 Section 3 petition does not seek to circumvent the noise control bylaw?
It's Gemma Cashman. That's correct.
Okay, and so the project expects to be able to comply with the noise control bylaw?
Gemma Cashman, that's correct.
In Section 2F of the letter, it asserts that the company does not need an exemption from the use restriction allowed in the industrial district. Well, what is the company's response?
Gemma Cashman, to clarify, it's similar to the argument I stated previously with respect to the converter station. The use of the cables, again, are not specifically listed as a permitted use in that zoning district. and therefore it is ambiguous and it subjects the company to risk and possible delay.
Thank you. In section 2-8 of H, excuse me, H is in Harry, 2-H of this letter, the town asserts that there's, quote, there is no legitimate reason to exempt applicant from complying with, close quotes, the bylaw regulating underground transmission lines. What is the company's response?
Gemma Cashman, the risk is really of third-party disputes or potential appeals of the zoning determination, especially appeals if they're designed just to impede the project development that would create unnecessary delay, burden, and undue expense.
Thank you. This is a big picture question. How would you describe the company's attempt at engagement with the town regarding zoning exemptions?
This is Kelly Smith for the company, and perhaps my colleague Ms. Perry can chime in as well. We have had preliminary high-level engagements. In one of our information request responses, we provide a table laying out some of the feedback from those high-level consultations as we step through the specific points within the zoning bylaw, or the specific points rather within our zoning exemption petition. So we have had preliminary discussions, and as I provided that example of the noise report and our revision to the operational noise report, that's a good example of how we do intend to work with the town going forward to comply and reach a shared understanding on as many of these points as possible. But we do still feel that the zoning exemption is important for the project due to the risks and the ambiguities and the potential for appeal and delay.
Well, on that point, does the company believe that it would be futile to apply to Somerset for the individual exemptions that it seeks?
This is Ms. Smith again. We do have concern about discretionary application of the bylaws in direct consultation with the town. So that is why we're seeking this exemption. We also do have concerns about potential appetite for litigation.
Tell me more about that potential appetite for litigation.
I don't know if we have it in information response, but
I might be able to help with that. I think that at least one of the zoning board members is a neighboring resident who has in the past litigated against the landowner.
Okay.
For activity at the Brayton Point site. I believe that is in what I would say is still an invalid information request response from the town. And that was a response to one of the questions that the EFSB asked of the town. There is an actual court decision from the land court in Massachusetts. I think it identifies the plaintiffs, and I believe one of them is an individual who is also on the zoning board.
Can I respond to that, Mr. Shea? I object to that. And in fact, that's an outrageous statement. That litigation that council is referring to is a zoning enforcement action on a plan development approval, which this proponent says that they can't get, or it's ambiguous somehow. And that owner, Brayton Point LLC, violated the terms of its permit. They violated the terms of cease and desist orders, and they put the town through a longer than 1 week litigation with Judge Foster in the land court. And Judge Foster ruled in favor of the town on the zoning violations and shut down the scrap metal operation. So any type of interjection of an answer that entirely valid litigation that was pursued by the town, forced by the owner of the premises that did not want to comply with the cease and desist order, is pretty outrageous to try to imply that the town is somehow litigious and that that's relevant to the standards for seeking a zoning exemption. So I'm only interjecting because it would be nice to just have the witnesses testify on these issues. And if something calls for a legal conclusion, council can raise the issue or object to your question. But council interjecting their commentary in between your question and then the answer from a factual witness from the project proponent is inappropriate under these circumstances.
Well, I hear you, and the rules of evidence are that witnesses testify and counsel do not. But at the citing board, we don't strictly adhere to the rules of evidence. And for example, your explanation that you just provided is very full and complete, and it's helpful in understanding the context of the litigation that Mr. Runge referred to. So your objection is duly noted. Now, but let me just ask: does the company have anything else to say on the issue of the futility of applying for the zoning exemptions that it seeks, the individual zoning exemptions?
This is Ms. Smith. I don't think we really have anything else to add there. I guess I would note that I had cited an information request where we provided notes on having stepped through the points of the zoning exemption petition. And I wanted
I'm sorry, you've cited an information request where we had
summarized high-level feedback from early discussions with some town officials. And that I just wanted to provide the number of that information request. It's EFSB-C-1.
I also needed to correct something, Mr. Shea, and I'm sure counsel was just mistaken. I'm not implying any improper conduct, but on that statement about a zoning board member being a member of the litigation of the enforcement action that I just talked about, that's not true. If he's referring to Nicole McDonald, who was submitted pre-filed testimony, she's on the planning board, not the zoning board. So that litigation involved her as a resident, found by Judge Foster to have standing because of the adverse effects upon her personally. But she was not acting in her official capacity. But in any event, it was not by the zoning board. She's on the planning board.
Okay, thank you. So, Ms. Smith, you mentioned the response to EFSB-Z-1 and the feedback that the company got from its contact with the town.
I think.
So, go ahead.
Sorry, this is all I would highlight there is that the tone of the feedback we received in those discussions is very different than the tone of the letter. So perhaps that would provide some context to your question about futility. We do think there's a path to move forward and continuing to communicate and coordinate. But we do have concerns about the overall stance of seeking these individual exemptions with the zoning board.
But just I just want to make some things clear, which I think we all know. With respect to the individual exemptions, there's been no application for special permit or anything else that would obviate the need for the individual exemptions.
Correct.
Okay. And is this based in part on the feedback you have received from the high-level consultations you've had with the town?
I'm sorry, I'm not sure I understand the question.
Sure. Let me repeat. Is this conclusion that it would be futile to make request individual exemptions? Is that based in part on your consultations with the town?
No, not as a result of those conversations.
Okay, what's it based on? What's the conclusion of futility based on?
I think I would say it ties back to just concerns about the subjective nature in which the standards could be applied, and ambiguity in how they're written.
So even if the company were to obtain all the exemptions and every special permit or variance that it needs, that would still be insufficient. Don't let me put words into your mouth, but I'm trying to understand your position. That would still be insufficient because special permits and variances can be appealed.
That's correct. That's exactly right.
Okay. And the nature of a lot of the terms of the standards requirement for a special permit, a lot of those, the nature of those things are subjective.
Correct.
Could I have just a second, please? I've got a technical issue. Just a
Oh, yeah,
moment.
sure.
Thank
Alan.
you. Okay, thank you.
I'm going to direct your attention to the response to EFSB-Z-6, where there's a representation that the company, through a wholly owned subsidiary, has executed an option to enter into a ground lease agreement with Brayton Point LLC. And the site owner is Brayton Point LLC. With respect to that ground lease, is there anything in the ground lease that would allow the company or refer to the company's need to make changes to the property as required to conform to conditions in the EFSB final decision? I can repeat that if you need me to.
If you don't mind repeating it, thank you.
Yeah, sure. With respect to that ground lease, is there anything in the ground lease that recognizes that the company may need to make changes to the property to conform to conditions set forth in the EFSB final decision?
This is Ms. Smith. Just to clarify, the agreement that's in place is an option to ground lease.
Okay,
The ground lease itself has not yet been finalized and executed.
okay. So that's very helpful. That kicks out a number of questions I had about the ground lease. In response to EFSB-Z-12, the company states that, quote, construction of the project is not likely to impact sand dunes, close quotes. But in the zoning petition, the company asked for relief from the Somerset zoning bylaw 9.3.2 paren B paren 2. And that provision prohibits person-made alterations of certain sand dunes. So my question is, if the company will not alter the sand dunes, then why does the company need an exemption from section 9.3.2 paren B paren 2? If you need me to repeat that, I can.
I'm just finding the reference. I apologize.
Sure. No, don't worry.
This is Ms. Smith. I believe that was in reference to the floodplain overlay districts and concerns about FEMA zones and how the company would make landfall with its underground transmission cables. I think upon further review, and this was covered in high-level consultations with the town officials as well, but because South Coast Wind is proposing to bury our export cables and make landfall using horizontal directional drilling, and because we intend to restore surface grades to the same level at which we found them and to not increase the quantity of impervious cover, I don't believe there are any concerns in relation to how we interact with floodplain overlay districts. So that's been an item that's been further clarified as the design has progressed.
Gemma
Thank-
Cash. Oh, sorry.
Ms.
Just to clarify, I just wanted to add, there is no zoning permit or other options. There's no use variance in response to that. So if it's a subjective standard, subject to the building inspector making that finding. So if he does find that it applies, then we would not be permitted to make that change. So that's the concern there. There's no specific zoning relief we could apply for.
And you're referring to, I'm sorry, what are you referring to? The overlay district?
Yes, the section 9.3 of the Somerset zoning bylaw.
Okay, so 9.3 is the overlay district, and the section that the subsection I referred to is 9.3.2 paren B 2, and that refers to specifically the sand dunes. But I guess your point is the sand dunes are just part of a larger set of restrictions.
Correct. And also included in that sentence are prohibited. So the proposed construction there would be prohibited in theory if that's the determination made by the building inspector, which is proposed risk for the company.
I'm sorry, which is what?
A risk for the company.
I'm going to refer to the response to EFSB-Z-13. And this response asserts that the company requires a comprehensive zoning exemption to avoid delays, and asserts that delays would be very harmful. So I'm going to ask you, please give me some concrete examples of how a delay in obtaining a zoning exemption would cause harm to the company or to the Commonwealth.
So, Dan Hubbard for the company. There's a risk that's associated with the with essentially attacks from third parties, which could result in delay. Delaying the onshore works has massive knock-on effects for the remainder of the project, which could really impede the ability for delivery and for the project to be available and contribute to the Commonwealth of Massachusetts green energy goals.
Please explain to the extent possible the knock-on effects that you refer to.
Sure, but I'm gonna hand it over to my colleague. She'll be able to address it with more specificity.
Yeah, this is Ms. Smith speaking. So as my colleague, Mr. Ryer, cited earlier, there's a number of work packages that the overall project is divided up into, from the offshore turbines all the way to the onshore point of interconnection. And so there's an intricate series of contracts that we'll be undertaking to deliver those components. And those contracts have interfaces and they have schedules and schedule risks associated with them. And so unforeseen delays to any package of the project, including the onshore scope, could really have knock-on effects on the overall construction timeline. Specifically, as an example, the project will get energized and commissioned from onshore to offshore. So that will provide, once we interconnect the grid, that will provide what's called the backfeed power to commission and energize the rest of the project. So without the onshore components in place and commissioned, the rest of the project can't go into operation.
Thank you. I'd like to now switch and talk about the termination of the purchase power agreements, PPAs. I understand that actually a lot of information has been. This is a fast developing area. It strikes me that things have happened lately, and you may have supplied, the company may have supplied the answers to some of these questions, but it's been so sudden and recent. I'd like to sort of clarify a few things for my own understanding. So regarding the termination of the power purchase agreements, what has been done so far?
Dan Hubbard for the company. I believe we touched on this on day one. Happy to revisit it, but we've engaged with the EDCs as well as the administration. We began several months ago exploring every opportunity possible, but after exhausting after exhausting any other option and the issuance of the RFP for round 4, it's been made clear to us that termination is the path that's expected of us going forward. And so to date, we've engaged with the EDCs. We are in confidential negotiations presently on on an agreement with them for winding up the PPAs, but unfortunately, it's still subject to confidentiality and somewhat limited in terms of talking details.
So when I said what has been done so far, I was referring to anything that's been filed with an administrative agency or something like that.
Thank you for clarifying. To date, there has been no filings with administration in Massachusetts.
Thank you. Okay, so in terms of, I'm just thinking about filings, and thank you, it helps me clarify my thinking. What remains to be done before the power purchase agreements are terminated?
As has been evidenced in the docket with other competitors, the conclusion of the agreement and then filing with the DPU, we anticipate that it would be a similar expectation. And so that, subject to their review, I believe, was a shorter period of time for public review.
And so the DPA has to, I'm sorry, the DPU, excuse me, has to review the termination of public purchase power agreements.
And approve, and that's what we've seen evidenced in the docket thus far for 83C3.
Sorry, for EC3.
I'm sorry, 83C3. So it's the dockets, I believe, 22-70, 71, 72.
22-70, 71, and 72. And which, but did they relate to? Did they relate to South Coast Wind?
Those dockets are, as we were winners under in the 83C3 process, those dockets are relevant to us, yes. But
okay.
The filings thus far are not regarding our company.
I'm sorry, repeat that last bit.
The filings that have been made by the EDCs for terminating power purchase agreements with competitors have not been related to South Coast Wind. South Coast Wind actually has a docket from 83C2, which is, I believe, dockets 20-16, 17, and 18, where we have purchase agreements as well that we anticipate filings.
Okay, but there have been no filings in those three dockets yet?
That's correct.
I should say there have been no filings related to the termination of the agreements.
That is a better way to state it, yes.
Okay. Could you provide the official documentation of the termination of the PPAs to the siting board once it takes place?
We'd be happy to do that. It'll be publicly available, but we provide it to you as well.
Thank you. I understand some things are publicly available, but when they're provided by the petitioner, it's easier to consider them as part of the record.
Mr. Shea,
Yes, sir.
I think that Eric Runge speaking. I think that a supplement to EFSB N-1 would probably be an appropriate way to put those in.
Thank you. Now, I'm going to refer to the testimony of Francis Slingsby that you provided as an EFSB N-1 supplement. It was EFSB N-1 paren S1 paren 1. Mr. Slingsby states that there is a draft solicitation pursuant to section 83C4 for up to 3,600 megawatts of renewable energy. My question is there an expected date by which such projects will be online? The projects selected pursuant to that solicitation will be online.
I believe that.
I'm sorry, who is this?
Sorry, Dan Hubbard. Apologies for that. I believe per the solicitation, which is in draft format presently, I think the CODs are 2031. I'd have to double check. We can verify. It'll just take one moment.
Do you want to take a moment now?
Yeah, I can. Yeah.
What section is it?
If this is too burdensome, we could take it as a record request.
We could get it after lunch. How about,
Yeah.
I'm sure we can find it for you, but
Okay,
a little time.
that's fine. Thank you. In the Slingsby testimony at 9, there's a reference to the energy generating facilities, quote, relatively high capacity factor, especially in the winter months when the region's natural gas system may be constrained, close quotes. My question is there a difference between the energy generating facilities capacity factor in the winter months as opposed to the summer months?
Indeed, this may be a more technical question, but the short answer is yes, there's higher winds in the winter months. And that's why it's a particularly valuable asset here in the Northeast.
And that's why it's particularly
Valuable in the Northeast.
so it's valuable in the context that natural gas systems may be constrained in the winter. Is that correct?
That is correct.
But with respect to summer peaks and heat waves, the lower capacity factor in the summer is maybe not as valuable.
I think that's more of a technical question, which I would ask that Kelly comments on. Would you mind repeating that question for her?
Sure, Kelly, are you on?
I'm here.
You're here, okay. So Mr. Slingsby said that there was a relatively high capacity factor, especially in the winter months. Mr. Hubbard confirmed that the winter month capacity is higher than the summer month capacity. Is that your understanding?
Yes, that's my understanding.
So with a lower capacity factor in the summer, does that affect the ability of the energy generating facility to supply power to the grid during various heat waves?
So excuse me. I guess not able to comment on specific weather patterns. It's a bit outside of my technical scope. But it is a known fact that offshore wind is a stronger resource in the Northeast in the winter months, which is particularly valuable in this region for energy security. But overall, it does have an average high capacity factor of around 50%. So it will be able to provide power certainly in the summer as well.
Thank you. In the Slingsby testimony at 13, there's a reference to the conditions necessary to a quote, final investment decision. Now tell me if some of this information is confidential, but who will make the final investment decision?
Ultimately, it's a decision that's made by the sponsors of the project.
And the sponsors of the project, you mean SouthCoast Wind or someone else?
Our sponsors being Shell, New Energies, and Ocean Winds North America.
Shell, New Energies, and Ocean Winds North America, and I believe those two are each 50% partners?
That is correct.
Okay. And how soon after a final investment decision can construction begin?
Yeah, this is Tim Ryer speaking. So I would say different aspects of construction can progress at a different rate. So there are manufacturing activities such as, cable manufacturing, steel manufacturing that need to happen onshore before, say offshore construction or onshore construction can take place. But certain aspects of construction, including, sort of onshore civil works and site works, can take place pretty soon, almost immediately after the FID, because other preconditions of FID tend to be, major consents and permits that need to be achieved, such as federal and state permits. So, the assumption there would be that the other permissions and application requirements that would be needed to construct otherwise would be filled at the time of FID. So it is really just sort of work scope by work scope, depending on what materials are needed and what sort of onshore fabrication and manufacturing is needed prior to installation and construction, offshore and onshore.
You talked a little bit about the conditions necessary for the FID. Can you expand upon that? You said there must be the necessary permits in place. Are there any other conditions?
I can speak to that in general. So I think, there are conditions that the sponsor companies will define in terms of the, investment case for the project. Also looking at general, supply chain progression, so such as getting, contractors identified, contracts in place as general considerations. Those would be some of the preconditions. I don't know if anybody else on the South Coast Wind team would like to add anything. Dan, for example.
I would, Dan Hubbard again for the company. I would just add that in addition to lining up all the engineering and the permitting and all those pieces, it's important to ensure you have your revenue streams. So power purchase agreements that are lined up, and then also financing to construct the project. Ultimately, all that goes into a decision. It supports the decision quality and the output for final investment decision to proceed. And go ahead, sorry.
Let me just say this. To the extent this is not a legal, to the extent this is basically just your understanding, not a legal question, but the final investment decision, do the investors have discretion as to whether or not to make this the investment, or if certain criteria are met, are the investors contractually obligated to invest the money?
I really can't speak to the confidential nature of the joint operating agreement and pieces like that, but ultimately I think it's safe to say that it's a decision that's made at a point in time with the information in front of them, and there's not necessarily a outcome that's predetermined. And I would just want to follow up, referring back to the question regarding COD under the present 83C4 bid solicitation, which is still in draft format. I just want to highlight under section 2.2.1.3 of eligible bids. Second paragraph references that for an eligible bid, it must have a scheduled commercial operation date, or a bidder must have a scheduled commercial operation date before January 1st of 2032.
January 1st or 31st? First of
2032.
2032. Okay, that's helpful. Thank you. I think that's all my questions. Let me just take a quick look, see if I missed anything. I appreciate how well prepared all the witnesses have been, and it's really made this go much more quickly. I believe, issue a record request for a copy of the ground lease when it's entered into.
I don't think it was.
I don't see a record request to that effect.
Oh, then why don't I make such a record request? Because I'd love to have a copy of the ground lease. I believe this would be record request. Let me go off the record for a second. Alan, is it 21 or 22?
Yeah.
'22.
22. Okay, so back on the record, yes, a copy of the ground lease for the facility on Brayton Point when it's entered into. That would be very helpful if you would produce that.
Mr. Shea, just to be clear, I'm happy to try to provide that, but it would be filed under a motion for protective treatment and redacted, obviously, in the public version.
Okay, I understand. I don't have any more questions. Thank you very much. Before we break for lunch, do any of my other colleagues on the siting board staff have questions on zoning or related issues? All right, then, Mr. Pucci, do you want to start your questions now, or would you rather that we break for lunch and you can have a fresh start after lunch?
If everyone else can stand it, I'm ready to proceed now. And then break for lunch at 1. Okay.
Okay. Go ahead, sir.
Okay, may I start? Thank you, sir. My questions can be answered by anyone on the panel. First, a couple of questions that relate to the legal standard for seeking zoning exemptions. First, with regard to seeking a zoning exemption, does South Coast Wind agree that the siting board encourages consultation with local officials and in some cases requires the proponent to actually apply for a permit before seeking the exemption?
Gemma Cashman, in some cases, yes.
And in follow-up to that, in instance where the siting board does not require the proponent to seek local permitting is in a situation where the effort would be futile, correct?
Gemma Cashman, yes.
Now,
Yes, part of the standard.
yes, right. Futility is one of the standards for the siting board having grounds not to require local permitting. Is that fair to say?
Gemma Cashman, yes, that's fair to say.
Has anyone before today, has anyone from South Coast Wind reviewed the zoning board letter dated May 1, 2023, which is attached to the pre-filed testimony of town witness Tim Turner? That's the letter referred to by the presiding officer. That's a question to the project proponent. I can, some of these questions I can direct to a particular person, and then that somebody else wants to answer, they can. But why don't I address that to
Mr. Pucci?
I guess Ms. Perry or Mr. Hubbard. Before today, has anyone from South Coast Wind reviewed the zoning board letter dated May 1, 2023 that the presiding officer questioned you about?
Mr. Pucci, before they speak, Eric Runge speaking. I will just say that the company did provide a response in part to that letter in EFSB Z-17. So I direct you to that.
And this is Kelsey. We have reviewed the letter.
Okay, if you reviewed the letter, when was that? Do you recall?
This is Kelsey. I don't have an exact date, but in May of 2023.
Okay, so, and then just quoting the letter exactly, I have a feeling I know your answer to this, but I'm going to ask, do you agree with the zoning board's statement that South Coast Wind has, quote, never contacted, close quote, the board, or, quote, requested time to present their project and discuss what, comma, if any, comma, waivers it may require from the zoning bylaw, close quote? Do you agree with their statement in that letter?
This is Kelsey. No, as we mentioned previously, at the town administrator's request, we have engaged directly with the town administrator on matters of interest to the town, and all communications have been channeled through him.
And with regard to that claim specifically, has there been any effort to document that claim that you're making today, that any discussions with the zoning board would have had to come through the town administrator?
This is Kelsey. That was a verbal request, so there's no documentation.
Is a town administrator typically a liaison for a zoning board?
This is Kelsey. I don't I don't know exactly for all municipalities, but this was the request from the town of Somerset to channel all communications through the town administrator on zoning related matters and all matters regarding the project.
But you don't have any documentation of that.
I do not.
That alleged directive on behalf of, quote, the town, close quote, that directive came solely from the town administrator? Is that where you're saying it came from, or from someone else?
The town administrator.
Okay. When you reviewed that zoning board letter in May of 2023, did it concern you at all that the zoning board made that pretty strong statement that nobody had reached out to them?
This is Kelsey. We are, interested in the town's concerns, and we are ready, willing, and able to meet with any town official in Somerset, including zoning board members, in an informal way, if they're interested in learning about the project.
Did you confirm anything in writing or formally with the town administrator confirming that you were requesting specifically a meeting with the ZBA after receiving that statement that they made in their May 2023 letter?
Sorry, can you repeat that?
I'll do my best. First of all, with reference, you knew about the zoning board's letter in May of 2023. We established that. I'm going to ask you a question actually preliminary to that. The statement in the zoning board's letter is fairly strongly worded. Would you agree with me? Where they're saying no one has reached out to us. They never contacted the board. It seems somewhat aggressive language. Would you agree with me there that the zoning board is expressing that no one has consulted them?
Yes.
Yeah, and so with that being worded in that way, did you feel it would be important to try to document to the town administrator, Mr. Town Administrator, we received instructions from you not to reach out to the zoning board or to channel all communications through you. Did you make any attempt to correct the aggressive statement which was made in the zoning board's letter?
We have had conversations with the town administrator since that letter was filed, and have expressed that we're willing to meet informally with any town official regarding the project.
Another reason for seeking zoning exemptions is where the zoning requirements are ambiguous, correct?
Correct.
And on the issue of alleged ambiguities, the presiding officer touched on some of these issues, but I'm not sure of your answer. On the issue of whether the proposed facility is permitted as an as-of-right use in the industrial zoning district, the zoning board states in their letter that it is in fact an as-of-right use as either a, quote, transfer station, close quote, or a, quote, electric substation, close quote. Is that correct?
This is Ms. Smith for the company. Yes, we understand the nature of the letter, and I think as was discussed earlier this morning, a big part of the concern is the ambiguity and the potential for third-party appeals.
Okay, well, if the ZBA is telling you that it's an as-of-right use as either a transfer station or electric substation, there's nothing ambiguous about that, correct?
I would say that correct as written, it's not ambiguous, but the potential for third-party appeals is still an item that exists.
Well, what if you have an unappealed permit from the zoning board, which incorporates that finding by the zoning board that this is an as-of-right use? How about an unappealed permit? Would that be ambiguous or subject to uncertainty or delay?
This is Gemma Cashman. That seems speculative to me. Can you repeat the question?
Well, on the issue of speculation, so saying that the zoning board's unequivocal statement that this is an as-of-right use, you're saying that that is not enough because that's potentially subject to appeal. Is that correct?
Gemma Cashman, that's correct. Under Mass General Laws, Chapter 48, Section 17, the third parties have the rights to appeal. If there's a decision issued, there are still appeal rights.
Okay, so if the zoning board issued a permit, I'm going to get to the permitting requirements under the zoning bylaw a little later. But assuming the zoning board goes ahead and issues you a permit under the local zoning bylaw, and it includes that finding that this is an as of right use, as the zoning board indicated it would do. And that permit is not appealed. Is that binding?
This is Ms. Smith. I think the concern is that the if statement for no appeals, that is a speculative risk to the project.
How long does it, how long do parties have to appeal a permit under the zoning bylaw?
Just a moment, thank you.
Eric Runge, speaking for the company, I think that they don't have the answer at their fingertips. If you know, Mr. Pucci, perhaps you'd care to let us know, but otherwise we can come back to it after lunch.
On that one, I'll accept an answer from council. Can we just get on the record? How long would a party have to appeal the zoning board's permit under the local bylaw?
Gemma Cashman, I believe it is 20 days.
Right. And so if there's no appeal within the 20 days, that permit would be binding, correct?
Gemma Cashman, correct?
Right. So the potential delay that we're talking about would be 20 days.
Gemma Cashman, if they filed an appeal, they could be stuck in the courts for much longer than that time period.
If they did, but if there's no appeal, you got 20 days. Once the 20 days runs, that permit is binding. It can't be challenged later, correct?
Gemma Cashman, correct?
And also under Massachusetts law, if there's an appeal of a permit decision, you still have the ability to proceed at risk, correct?
This is Ms. Smith for the project. I can comment that proceeding at risk is, as the term indicates, a substantial risk to the project due to the importance of the interconnection of the entire project to Brayton Point. So the risk, there's no way to guarantee that no appeals will be filed, and there's no way to guarantee how long the appeal process could take, particularly if it's on the order of years. So that is a major risk to the project.
I'm sorry. I'm sorry. Go ahead.
And it is possible that if all other permits were in hand, that there might be a way for the project to proceed at risk, but that is would be an enormous consideration and particularly risky to a project that's needed by the Commonwealth to achieve renewable energy targets.
That term at risk under proceeding in the face of an appeal of a permit decision, that goes to really for a project proponent to proceed if it's either a NIMBY type of appeal or a frivolous appeal, correct? In other words, there's really no risk at proceeding with development activities in the face of an appeal which is likely to ultimately be dismissed. Is that correct?
I would still say that that's a risk to the project. It's also a matter of how the appeal is perceived, which is difficult for us to speculate on.
Next on the zoning bylaw provisions, minimum setback requirements. SouthCoast Wind expects to be able to meet the minimum setback requirements, correct?
As I mentioned earlier, I think that that's something that will continue to be refined during detailed design. And we need the latitude to be able to design the converter station in line with the industry standards and the safety protocols for equipment layout, access, clearances, fire protection, and the like. And so the exact boundary of the converter station is still being fine-tuned in detailed design. So it's a bit too soon to conclusively say that we would be able to meet the setback requirements.
And at your current 30% design completion, as of now, you don't anticipate the need for exemptions from the setback requirements. Is that fair to say?
I can't make that statement at this time.
So let me get it straight. Are you asking the siting board then to just give you carte blanche with respect to setback requirements?
I guess I would contextualize the fact that SouthCoast Wind is planning to lease a 10-acre parcel within what's currently a 300.
I'm sorry, I couldn't hear you. A 10-acre what?
Parcel within what's currently a 300-acre brownfield industrial site. So in terms of setbacks from residential and other users by being insulated on the industrial site, we are already quite contained. And I think we would still need to have those conversations with the town and understand what the perceived requirements are for a 10-acre lease within a larger industrial site. So I can't really comment at this time whether we have the ability to meet the setback requirement that might be applied to us as a tenant within the larger industrial property.
So then just in terms of follow-up to my question is, what do you expect the siting board to do? Just give you carte blanche with respect to setback requirements? In other words, you're seeking an exemption. So you want something from the siting board. So what do you want from them? Carte blanche?
This is Ms. Smith again, I wouldn't use the term carte blanche. I think that minimum requirements, and I'd have to confirm exactly what those are, usually on the order of 25 to 50 feet. We might not be able to achieve that all along the parcel boundary.
With regard to the provisions for off-street parking and loading requirements, both the zoning bylaw, which is in evidence, and the board's letter, which is also in evidence, confirm that the industrial zone requires one parking space per 1,000 square feet of gross floor area and one loading space per 50,000 square feet of gross floor area. And my question is, there's nothing ambiguous about that, correct?
We agree with that statement as was covered previously. It's for the parking and loading, it's the requirement, I would say, is not particularly relevant to a converter station that's going to be fenced in and have secure access. So it will be designed with the necessary access required for operations and maintenance for the periodic inspections and activities that will take place. We do believe that the 10-acre parcel has sufficient room for a few parking spaces, and there is nothing ambiguous about the requirement. It's not particularly applicable to a project of our type, however.
Well, first of all, with regard to the requirements themselves, you don't have any reason to anticipate that you would not be able to comply with those. Is that fair to say? Whether or not you needed it or not, can you comply?
And this is specific to a few parking spaces?
Off-street parking, one parking space per 1,000 square feet of gross floor area.
I believe we would be able to accommodate that once the detailed design is refined. And I think that speaks to the overall general point that we intend to meet the zoning requirements to the extent practicable for the detailed design and function of the converter station. And we'll continue to work with the town in doing so. And what we're seeking here with the zoning exemption petition is to avoid delay from subjective determinations and third-party appeals.
Well, I'm going to get to the point where how long a application would actually take as we're sitting here today. But we'll leave that for now. In any event, at this point, you don't anticipate needing an exemption from those parking or loading requirements. Is that fair to say?
I believe that's correct for the parking.
And by the way, the concept about unmanned, I'm just trying to understand this. You're not saying no one will ever go into this facility again, correct? Once it's built? I mean, somebody has to check on it, don't they?
Correct. The term is used to apply to the situation that it's generally unmanned. So on an average day, no one will be present at the site, but it will undergo periodic inspections and maintenance from likely a two-person crew. It depends on the nature of the activities. Just in keeping, honestly, in similar line with how the existing facilities owned and operated by National Grid are checked on and maintained periodically.
Right. And those maintenance personnel, they'd park somewhere, right, on site. They don't fly in by helicopter. They would typically drive in a vehicle.
They do typically drive in. I've seen at other substations, sometimes they pull up and just park alongside gravel roads outside, depending on the nature of the site. Sometimes they'll pull all the way into the converter station facility itself, which will have its own access paths. And typically, because it would be a two-person crew, they wouldn't necessarily need dedicated parking. They could perhaps just park and leave their car within the existing access paths that are already designed into the converter station.
Well, it's not a site that you would want just anybody to just be able to drive up to and park anywhere, right? It's got to be a secure facility. Is that fair to say?
Correct.
Right, that with things like designated known parking areas, security, that type of thing, correct?
The greater Brayton Point facility will have its own security and access. And for example, our neighbors at Prismian, they'll have their own access road, security gate, and parking. I was speaking specifically to the SouthCoast Wind parcel.
Right. Yeah.
Our converter station will also have its
Wait,
own.
I'm sorry, you dropped out. Our
Converter station will also have its own fence.
And it will also have its own parking area, correct?
Well, what I was speaking about earlier is there's not necessarily a need for designated parking. The access paths within the fenced-in converter station can also serve as parking for the type of two-person crew that might periodically visit the converter station.
What if something needs to be replaced from the facility? Do you need any type of loading area for that?
The access roads within the converter station would be designed to be able to appropriately handle the types of vehicles or maintenance needed to access and remove. So a loading area might be, again, on a path directly adjacent to a piece of equipment.
On the issue of onshore cable export, the zoning board letter notes that public utility uses are allowed as of right in the industrial district. So there's no need for an exemption with regard to that project component, correct?
I'm sorry, could you repeat the project component in question?
Yeah, could you read it back maybe?
What was the reference?
If Mr. Brock could read the question back, I don't know if that's possible.
yes. On the issue of onshore cable export, the zoning board letter notes that public utility uses are allowed as of right in the industrial district. So there's no need for an exemption with regard to that project component, correct?
Is this in relation to the use provision?
Correct.
I think, as was spoken about earlier and Ms. Cashman spoke to as well, the concern is about the risk of the third-party appeals.
Okay.
So I think
Same consideration for the underground transmission lines. Other than these hypothetical third-party appeals, there's no need for an exemption according to the zoning board's letter, right? It's an as of right use. Fair to say?
I think, as was spoken about earlier, there's some ambiguity in how the definitions of uses are written, but if we're going off of the letter submitted in May as clarification as to which uses apply, there's still the concern about third-party appeals.
Now, with respect to plan development approval under the town zoning bylaw, can anyone explain what SouthCoast Wind's understanding of that requirement is?
Just while they're looking that over, Eric Runge speaking for the company, there was a response again to EFSB Z-17 in writing that talks about some of this.
All right, if no one's able to answer that for some reason, I'll just move on from it. Let me ask a question. It's just referencing the bylaw. It's plan development approval is under 6.10, correct? Section 6.10.
Chairman Cashman, that's correct.
Okay. And if South Coast Wind was not seeking an exemption, and if they were not granted an exemption from the siting board, they would in fact have to apply for plan development approval from the zoning board in this case, correct?
Chairman Cashman, correct.
Okay. And specifically, does South Coast Wind claim that seeking plan development approval from the town zoning board would be futile? That's a question for the witnesses, fact witnesses. Does anybody have an answer for that?
Can you repeat the question, please?
Yeah, could you read that back, Mr. Brock?
Specifically, does South Coast Wind claim that seeking plan development approval from the town zoning board would be futile?
That was the question. And then I asked in follow-up, I'd like an answer to that from one of the South Coast Wind witnesses.
Kathleen Freeman, can we respond after the break? It's after 1 o'clock.
I'd just like an answer now, and then we can break. I mean, if that's fine with Mr. Shea.
I don't know. Are the witnesses capable of answering now, or you want to take a moment to think about it?
We want to take a moment, Kathleen Freeman, take a moment to think about it. This is not something you answer off the top of your head.
I understand. Okay, so why don't we break? It's 1:04 now. Why don't I see you all back at 2:04, 4 minutes after 2, and we'll take a lunch break now. Thank you very much.
Thank you very much.
We're off the record.
Go
Let's
on.
see. I'm sorry.
Sorry.
Yeah, I gotta say, we're off the record. Is everyone here who needs to be here to resume?
Yes, for the company.
Yes, for the company. Mr. Brock is here. He's the essential person. The sine qua non of a stenographic transcript. Does anyone else have any Latin phrases they'd like to state right now before we go on the record? Mr. Green smiles. Yes.
I apply that phrase to the need to have a PPA. Never mind. And it is not a sine qua non.
Race.
Yes, that's a dispute. As I recall, Mr. Pucci was asking questions, and there was a question pending. To which Ms. Freeman said, "This is not the sort of question you answer off the top of your head," and that's fine. I would like to go back on the record and have the last question reread. Would that be all right with you, Mr. Pucci, rather than re-ask the question?
Yes, that would be fine.
Okay, so let's go back on the record. Mr. Brock, let the record reflect that we've taken a lunch break, and I request that you read back Mr. Pucci's most recent question.
Specifically, does South Coast Wind claim that seeking plan development approval from the town zoning board would be futile?
Okay, does anyone want to answer that question?
Yeah, Dan Hubbard for the company. Thank you very much. I wanted to get one point of clarification from Mr. Pucci, if that's possible, just so we can answer efficiently. Would that be okay?
Go ahead.
Thank you. So, Mr. Pucci, you'd referenced earlier on communication from the zoning board. I just want to make sure I'm understanding. So it was penned by a chair, Stephen Corradet. Is that correct? And it was on May. The letter was dated May 1st. Is that the one?
Yes, but my question did not involve that.
No, understood. And it was addressed to to the town administrator?
I don't know. Whatever the letter is attached to Mr. Turner's testimony.
Okay, that's the letter dated May 1st. It was the testimony submitted on June 5th. I just wanted to make sure I oriented myself to the question. The company would respond to that in reflection of that letter which you cited, Mr. Pucci. And I say that we do have a reasonable belief that it would have such effort would be futile. And the reasons for that are really contained in the letter you cited. And it begins with the first paragraph, which begins with which is the communication from the zoning board.
I'm sorry, which begins with what?
I'm sorry. It begins with the letter from the zoning board to the town administrator, and it begins with, at its regularly scheduled meeting held on April 20th, 2023, the zoning board of appeals voted unanimously to oppose the waiver or exemption of.
I'm sorry, I just can't understand you. The zoning board of appeals, what?
I'll go slower. I apologize. The zoning board of appeals voted unanimously to oppose the waiver or exemption of any of the town's zoning bylaws as requested in the petition of Mayflower Energy LLC, hereinafter Mayflower Wind, to the Energy Facilities Siting Board. It further continues to utilize language going into each one of the elements that you picked through earlier on, accusing South Coast, then Mayflower, of inaccuracies, untruths, unsupported assumptions. It also later indicates that where South Coast had indicated desire to work with Somerset zoning, with the board, said this has never been farther from the truth at hand. Additionally, it says that we had failed and refused to attempt to resolve zoning issues. It continues with similar rhetoric, is that we've had failure due to our failure to reach out with the board to discuss this project in an open session, instead of subverting bylaw through use of general laws, chapter 40, section 3, which obviously is applicable to in the certain case. So we've been accused of untruths and subversion. And additionally, the zoning board in this letter, which was communicated from the zoning board to the town executive, and I assume, Mr. Pucci, that the town administrator is the executive for the town and speaks on behalf of the town, to communicate this to the EFSB. And then just one last point I want to mention on this, and I would like to go back and have my esteemed colleague just address one thing, is this information was addressed specifically to the town administrator, not to SouthCoast. And the letter itself was dated May the 1st of 2023. And it was attached, and I'm going to hand it back to Kelsey in a moment, but it was attached to the testimony of Mr. Turner, which was made available to us on June the 5th. And Kelsey, you wanted to correct
Yes,
something?
This is Kelsey. I had my dates wrong earlier when Mr. Pucci asked when we reviewed the letter. We reviewed the letter in June of 2023, not May of 2023.
So to summarize in very brief, yes, we have reasonable concerns that it would be futile. Thank you.
Okay, so, well, let's start out, first of all, where in the zoning board's letter does it say that it intends to deny a application for a plan development review? Anywhere?
So you're asking if the zoning board made a future determination about denying an appeal or denying an application?
Yeah. I'm asking where in the letter does it say that it intends to deny a plan development application under the town zoning bylaw?
I think it would be imprudent for that board to make a future determination like that. However, what they did indicate was that they had already voted unanimously to oppose the waiver, which I would think gives a good indication of the sentiment.
The denial of the waiver goes to the requested exemption to the citing board, correct?
Yes.
Right. So the letter speaks for itself. So I'll repeat then the questions that I asked earlier, which maybe those now have a different answer as well. When you got this aggressive letter that you just described, and your witness now says she actually didn't see it in May, she only saw it in June. Well, when you got it in June, when it's making aggressive statements about no one has reached out to them and they oppose the zoning exemptions, did you want to correct the record at all to the town administrator to say, oh, Mr. Town Administrator, you had instructed us not to reach out to the zoning board? Didn't you want to do anything like that to try to correct the record? If
with
this is so aggressive?
Are you asking me if I wanted to correct the record with the town administrator who already knew that statement?
Right. You were okay with the zoning board writing to the town administrator in that manner?
Certainly, we weren't pleased with it.
Did you do anything about it? Did you object to it? Did you express any problem to the town administrator?
Well, we've corrected the record then, and we were subject to discovery from the town since then.
Okay, so and another thing, town administrator is, and any of your witnesses can answer this, including counsel if they want. Town administrator is not, in fact, the executive authority for the town of Somerset. Isn't that correct?
He's certainly been, and I can defer to Kelsey on this for her comment as well, but that's been the single point of contact by which we've been instructed to interface with the town of Somerset. Kelsey, is that fair?
That's correct.
And I would also offer, given there's additional experience in the room, Kathleen, if you've experienced similar things on other projects.
Yeah, Kathleen Freeman. For 10 years, I've worked with the largest utility in New England on several transmission projects before the siting board. And in my experience, the typical interaction is with the town manager and the town administrator. And in those many proceedings, I've had many meetings with town administrator and town manager. That is the typical industry practice.
My question is the executive authority of the town of Somerset the town administrator? And let me clarify the question. Let me get basic. Executive authority. So if we talk about the federal government, we would say the executive authority is the president of the United States. Then we would say the legislative body is Congress. We would say the judicial body is the Supreme Court. Talking analogous now to a local municipality, the executive authority is the Board of Selectmen, correct? Analogous to the President of the United States.
Indeed, but certainly the president doesn't issue letters with folks that they do business with. I would also maybe point to there's a May 1st letter that was signed by the town administrator communicating expectations. And so the town, I believe, through that relationship has communicated to us that is the point of contact. Additionally, we have met with the select board previously.
I'm talking about this topic that you're talking about, the town administrator's executive authority. First of all, do you agree with me to correct that? The town administrator is not the executive authority for the town of Somerset. Is that fair enough?
I'd be happy to defer here to our council. Thank you.
Well, I'm just reading Mr. Pucci, Eric Runge speaking for the company, and I'm looking at a description of the town administrator from their website, Mark Bulucci. And it says here, the town administrator is the chief administrative officer of the town, etc. So
where does it say he's the executive authority of the town?
well, we're not going to quibble over whether he's the executive authority or the chief administrative officer. He's the one who is out front dealing with the project and has instructed the client to speak with him about matters related to the project.
And where is the written confirmation from the town administrator denying any effort to reach out to the zoning board? Is it documented anywhere that the town administrator, as the chief administrative agent for the town of Somerset, ever instructed South Coast Wind that they are not to follow up with the zoning board to discuss the zoning bylaw in its jurisdiction?
So I'll defer to Kelsey, who can answer the question on how the town administrators has directed the project to communicate with the town.
Yep, I know that we've said this before, but yeah, again, at the town administrator's request, we have channeled all of our communications through him. He has not outright denied a meeting with the zoning board, but again, all of our communications with town officials are through the town administrator.
And similarly, he's coordinated all of our meetings as well.
Okay, we'll just leave it at that, if that's how you want to leave it. Oh, and I'll move on. Plan development review under the town zoning bylaw is similar to as of right site plan review commonly seen in municipal zoning bylaws. Isn't that correct?
Gemma Cashman, yes, it's similar to site plan review.
In other words, it's not really a matter of whether a plan will be approved or denied. It's just a matter of what conditions should be imposed on the approved plan for an as of right use. Is that fair to say?
That's fair to say.
And section 6.10.2 of the zoning bylaw for plan development approval sets forth various requirements which can be incorporated as conditions of approval, correct?
That's correct.
For example, subsections A, B, and C, those are all small letter A, B, and C, address landscape screening standards, tree or substitute vegetated plantings, and ingress/egress requirements. Is that correct?
Gemma Cashman, yes, that's correct.
These are more factual witness questions for witnesses as opposed to legal issues. For South Coast Wind witnesses, do you find any of these provisions particularly onerous or unusual for industrial or utility related development? Anyone want to answer that? Find those requirements particularly onerous?
We're in the process of pulling up our own copy of the provision. Can you please provide?
If you're pulling it up, yeah, so I'm referencing it's on page 32 of the bylaw, A, B, and C.
This is under site plan? Oh, no, I see now.
Plan development review. Earlier, my question was if it's analogous to site plan review. You've already answered that, which it is. And now I'm just asking specifically about the bylaw. I'll repeat it so now that you're in there, is section 6.10.2, subparagraphs small a, B, and C. Those have requirements for, they address landscape screening standards, trees or substitute plantings, and ingress/egress requirements. Do you see that?
Yes,
I'm sorry, who's answering?
this is Ms. Smith.
Thank you.
And do you find any of those provisions particularly onerous or unusual for industrial or utility related development?
Specific to landscaping requirements, we do. So some landscaping requirements and especially related to shade trees or other things with deep root system.
I'm sorry, or other what?
Or other vegetation with deep root systems. I have the potential to conflict with ground grid design in the substation, and could also perhaps grow to a height that would grow over top of the fence and potentially come within clearances that are unacceptable for the electrical equipment.
I'm sorry, come within clearing what?
Clearances that are unacceptable for the electrical equipment. And I believe we speak to this further in our, I think it's further documented in one of our information request responses, but I don't have the reference handy.
At your 30% design completion, is there any reasonable basis to claim that you would not be able to reach satisfactory conditions with the zoning board under any of these subsections of section 6.10.2?
I think, as I stated earlier, as the design for the specific layout of the converter station equipment and the necessary clearances matures, it is possible that it's certainly possible that we would have challenges meeting the requirements for things like vegetative screening and setback requirements.
But is there any basis to conclude that you wouldn't be able to reach satisfactory conditions?
The concern is to do with the potential for third-party appeals as well. So we intend to continue communicating with the town and working on discussion and provisions that are acceptable for the safe and effective functioning of the converter station. So it is possible that consensus could be reached on some of those points, but the concern is the potential for third-party appeals.
In section 6.10.2, it also notes that, quote, in addition, close quote, to the requirements I just asked you about, such developments are, quote, subject to all provisions set forth in this bylaw, close quote. Is that correct? You see that?
Section
6.10.2 is in the intro.
I do see that.
Okay. And are you familiar with the requirement that for certain uses involving potential releases of dust from industrially zoned premises, there is a requirement, quote, that all dust and fumes incident to storage or handling are effectively confined to the premises, close quote.
During operation of the facility, there won't be any dust produced. During construction, of course, there would be excavation activities and the project would follow best management practices.
Now, I'm just asking, are you familiar that that's a requirement in the zoning bylaw?
I had not seen that exact. provision.
Are you familiar with Land Court Judge Foster's ruling on that dust and fume containment requirement in his decision affirming the zoning board's cease and desist order and joining the continued operation of the scrap metal business, which your owner, lessor, Brayton Point LLC, previously allowed on the Brayton Point site? Are you just
Yes.
familiar with his ruling?
Wait.
I apologize, Mr. Brock. Sorry. Sorry, Ms. Freeman.
Yes, we are familiar. I believe you had provided a copy of that land court decision with your response to our IRs.
Do you agree that enforcement of the standard that Judge Foster articulated in that decision would be an appropriate condition on your intended pre-construction and construction activities at the Brayton Point project site?
Kathleen Freeman, different circumstances, different types of project. No, I don't necessarily agree. The operations that were subject to that land court decision were scrap metal operations. We are not a Massachusetts stationary source, as was the scrap metal. So apples and oranges.
What about for potential releases? Would you agree that Judge Foster's standard would apply? He talked about what effectively confined means.
Objection. We're not here to talk about the land court decision. I think it's fine to reference it, but we're not going to have an analysis of the land court decision here. I think it's already been explained that the project, when operating, will not be involved in storage or handling. So the zoning bylaw you mentioned is not even applicable here. We're talking about only dust from construction. That's on the table only.
I'm interested. So Mr. Pucci has talked about the land court decision. And okay, so you say that's not relevant, Mr. Runge. Mr. Pucci, do you have a response?
Yes, I do. It's absolutely relevant. It talks about, first of all, we just established the zoning bylaw in 6.10.2 subjects plan development approval to all provisions in the zoning bylaw. And I just referenced the effective confinement requirement of dust and fumes requirement of the bylaw. And I asked a simple question, whether Judge Foster's interpretation and application of that dust confinement requirement is an appropriate condition of approval that should be applied in this case to pre-construction or construction activities.
So you're not arguing, I mean, you're not arguing in this question collateral estoppel.
No.
Okay. All right. So it's just a factual question. Do the witnesses think that this would be a reasonable requirement? That's a factual question. It's not legal. I'll have to overrule the objection and let the witnesses answer as well as they can.
Okay, Kathleen Freeman, our response to the record request from last week, I believe it was record request 8 or 9, should address this, but we did carefully review the land court decision applicable to a Massachusetts stationary source or operation. We would distinguish our project as for construction. We do expect that any dust emissions would be minimal. We would, as stated in our record request response, which you will see, we'll get today, will be using best management practice to avoid and minimize dust. However, it would be a difficult standard to implement. And in my reading of that land court decision, I understand that the scrap metal operations did particulate matter monitoring, and there were issues with that as a way to gauge compliance, and there were a lot of problems with that compliance or the monitoring, because particulate matter readings included not just dust, but vapor, pollen, and other factors that, again, it could be a complicated means of ascertaining compliance with no dust outside the boundary of the site. But with that said, again, I think the comparison of a construction project versus an operations project is not a good comparison, and not a fair comparison. It's, again, apples and oranges. So I think the standard, we would certainly comply with the requirements, the Massachusetts requirements, and we would make every effort to the extent practical to comply with the town's requirements for ensuring that dust does not leave the property, but that's a very difficult standard to meet.
I'm talking about the pre-construction and construction phase. I'm assuming from your prior testimony that there isn't going to be release of dust from the facility once your operation is underway. I'm talking about construction and pre-construction.
Yes, and I'm talking about construction also.
Right. All right. So
no emission of dust from operations.
okay, so limiting it to pre-construction and construction activities, are you saying that you cannot comply with the standard articulated by Judge Foster in interpreting the town's bylaw provision?
I can't say. It's how would you demonstrate compliance? Or there were the testimony in that decision was replete with issues on how to demonstrate compliance, and I don't think that issue was resolved. So I think it could be subjective, it could be complicated, and again, I think the circumstances are very different here. So that's a difficult question to answer, and I don't.
Well, yeah, I'm not comparing the scrap metal operation to your construction activities to build your facility. What I'm talking about is interpretation of that particular zoning bylaw requirement as Judge Foster had interpreted it. And I'm asking just simply, can you comply with that standard or not with regard to your construction?
So I'm going to ask Mr. Pucci to state clearly what that standard is. If you're going to keep asking the witnesses questions about the standard in some other case, I want an articulation of what the standard is.
I think that's appropriate.
That essentially, I'm not reading from the decision, but from memory, that if the construction causes perceptible levels of particulate matter or dust into the residential neighborhood, that's a violation of the standard. Can you comply with that?
I would argue that that's a subjective standard from what my reading of that decision, that even if you measure particulate matter PM 2.5 or PM 10, I believe it was the town's own expert witness testified that it would not be visible. You would not be able to perceive that particulate matter unless there were massive amounts. And then it would be like a gray area. So again, it could be a very subjective standard. And that itself is a problem.
Are you saying that you intend to release particulate matter 2.5 into the Brayton Point residential neighborhood from your construction activities?
I'm saying we will comply with the Massachusetts requirements, and we intend to avoid or minimize any kind of dust release. And as we've stated repeatedly in our MEPA filings and in our response to information requests, that we will do what we can to minimize those efforts.
I don't know what that means. First of all, what are the Massachusetts requirements that you're talking about?
Well, in our response to record requests, we do use an indicator which was used in the land court decision of the Federal Clean Air Act National Ambient Air Quality Standards of 150 micrograms per cubic meter over a conservative 15-minute period. So and that's one indicator, but I would say that that's not applicable to us because we are not a Massachusetts stationary source. So we would do what we could to avoid or minimize dust. And as we've stated repeatedly, any emissions from our construction project would be localized and temporary.
So other than doing what you can in your own discretion, you're saying that there are no state, federal, or local requirements with regard to having to effectively contain dust and particulate matter during your construction activities. Is that what you're saying?
No, I'm not saying that. Don't put words in my mouth.
That's what I thought you said.
No, that's not what I said.
Correct me, please.
In fact, we could read back the record if that would help.
Well, you just said that the Massachusetts standard that you referred to doesn't apply to you.
It doesn't. It's used by some developers as an indicator, but again, we are not a Massachusetts stationary source.
All right, so I'll ask the question a different way. Fair enough. What you said, I did put words into your mouth because I misunderstood it. Then I'll ask the question directly. Other than doing what you can, are there any state, federal, or local requirements applicable to your project, to your construction activities, with regard to the effective containment of dust or particulate matter from your construction site?
I can't think of any off the top of my head now, but certainly I'm sure there are requirements. What I can think of are under the Massachusetts contingency plan is there are requirements then when working at a brownfield site that you minimize in exposure to contaminated dust or soils. And we have addressed that in our filings that we intend to work closely with the Massachusetts Department of Environmental Protection and to file a utility release abatement measure, which will set forth public health controls, which we will abide by. That will be reviewed and approved by the Massachusetts Department of Environmental Protection. And that will include how we manage soils we disturb at this brownfield site, any dust we kick up or any groundwater. So that will be binding on us and that will be publicly available for review.
Do you agree that the Brayton Point project site involves unique challenges for the control of the release of particulate matter, dust, fumes, or other contaminated elements in the air, in that the project site is on a peninsula immediately upwind of the Brayton Point residential neighborhood?
Kathleen Freeman, you want to take that?
I was just gonna add some clarification.
I'm sorry, who's speaking?
This is Ms. Smith. I think we again have talked about this on a prior day, but with the operational conditions of the scrap steel operations, for lack of a better term, I think a lot of the concern had to do with the fact that that was operating from the wharf area to the eastern side of Brayton Point. And I would say that that's in direct line of sight to the Somerset neighboring community. An advantage of the siting of the proposed SouthCoast Wind project is that we are located just to the west of a grassy berm that I believe is about 30 feet high. So that is another just natural mitigation that will shield our construction activities from nearby abutters. In addition to that, we do have a long list of proposed mitigations for dust and material control provided as part of our DEIR and our FEIR and various information request responses. And I do believe there are standards applicable to dust, odor, and noise. And those are listed in comment response section 15.2.3.1 of our DEIR submission. Specifically, the reference is 310 CMR 7.09 dust, odor, construction, and demolition.
I think it's discussed further in section 13.4 of the DEIR. And we do then speak to our compliance with that regulation.
Are you aware that your intended owner or lessor, Brayton Point LLC, has been subject to enforcement actions by Mass DEP, the US EPA, and most recently, the Mass Attorney General's office?
We are-
Kathleen Freeman, I've got this. Yep, Kathleen Freeman. Yes, we are aware. You have shared those enforcement actions with us in your response to the IR, in addition to the land court decision. Again, we are not the landowner. We, as an innocent tenant, protected from liability under the Massachusetts Environmental Policy Act and Chapter 21E, we intend to ensure we meet every criteria for maintaining our innocence, and we will ensure that any activities we do not worsen conditions at the site or do not put anyone at risk. And you're speaking to a brownfields attorney who's done several complex brownfield sites. So I am confident that this project will protect the public and will do the right thing.
So South Coast Wind understands and appreciates the residents' concerns concerning any proposed site development activities which might involve Brayton Point LLC. Is that fair to say?
We are aware and continue to engage actively with the community. And so we have certainly heard the concerns of the community and understand some of the historical discussions around the site.
Do you agree that the residents in the vicinity of the Brayton Point project site have the basic right to breathe clean air, sleep peacefully in their residences, and not be subject to adverse health consequences from operations at the Brayton Point project site?
Dan, you want to take that? Or can you take-
Go ahead.
Kathleen Freeman, yes, we agree.
Thank you. I'll touch on site contamination and environmental issues later, but just following up on some of the questions on days 1 to 3 from last week in these proceedings. I recall that actually it was you, Ms. Freeman, and again, if I'm putting words in your mouth, correct me, but I distinctly remember you referring to Brayton Point LLC, the lessor, quote, mucking around, close quote, at the site presently. Do you recall that? Mucking around?
I do, Kathleen Freeman, I do, and I apologize for the choice of words, but anything that happens in our project area on the site, South Coast Wind, as an innocent tenant, not responsible for conditions that exist there now, is a concern for us and could affect our activities. So we are in close coordination with the landowner, Brayton Point LLC, and with Prismium.
Yeah, I have some questions about that. And by the way, I appreciate you saying that and acknowledging you said mucking around. When I'll raise my hand if I'm trying to make you look bad, and I'm not. I'm just following up on what you said. The mucking around though was that concerned work, work in potential contaminated areas under the mass contingency plan, right? When you said mucking around, you're talking about sort of work in and around contaminated areas, correct?
Kelly Smith speaking. If I recall correctly, that discussion was in the context of some of the grading and site preparation activities that Brayton Point LLC would be performing. And it was, I think, specifically, again, if I recall correctly, to explain why the South Coast Wind stormwater system design is not in a detailed phase. So I think it had more to do with general site and grading earthwork activity and less to do with anything pertaining to potentially contaminated material.
South Coast Wind has also said that it has no control actually over what Brayton Point LLC does. Is that correct?
We are separate entities.
Would you agree that and I promise this is the last question about mucking around. would you agree that the phrase mucking around does not instill a reasonable degree of comfort and assurance that pre-development site work by Brayton Point LLC is being done with adequate concern for the environment, public health, or the requirements of the mass contingency plan?
Kathleen Freeman, as the person who chose those words, I apologize. That was not the intention of that choice of words. We just monitor what's being done in areas that affect our proposed project area. Again, we have been working closely with the landowner and with Prismium to coordinate our efforts and ensure that we understand how site conditions are changing and that we adapt our own plans to those improvements.
Okay. And in accordance with my promise, I am done with the term mucking around. And now returning to the issue of plan development review under the town zoning bylaw. If one undergoes that process, the first thing you do is you file a site plan with the zoning board. And within 15 days of receipt, the zoning board refers that to the planning board for review. Is that correct? If you want to look at the reference, it's on page 32, section 6.10.3.
Gemma Cashman, the dates aren't specified in that particular section, but yes, that is the spirit of that language in section 6.10.3.
Section 6.10.3, subparagraph B as in boy, says within 15 days of receiving a site plan in proper order for approval of a plan development, the Board of Appeals shall refer such request to the planning board for review. Is that correct?
Gemma Cashman, yes, I see that language.
Okay. The planning board, proceeding under the same section, the planning board then has 30 days to, quote, transmit to the Board of Appeals a report accompanied by any material, maps, or plans which will aid the Board of Appeals in judging the site plan and in determining special conditions and safeguards, close quote. Is that correct?
Gemma Cashman, yes.
And the zoning board shall not act on the site plan unless it has received the planning board report or 30 days elapses from the date of referral, whichever is earlier. Is that correct?
Gemma Cashman, yes.
And now more to SouthCoast Wind. Does that requirement and that time frame seem unduly onerous to you in terms of required submissions and an expected time frame for action?
Do you want to take that, Kathleen? This is Kelly Smith. I would not say that 15 days or 30-day turnaround periods are particularly onerous taken on their own.
And earlier, we talked a lot about outreach to the zoning board, and you testified to that. Has there been any outreach to the planning board?
This is Kelsey. I have made requests to the town administrator to meet with the planning board via email.
Did he respond to those requests?
He did not.
All right. So nothing scheduled as of now.
Nothing is scheduled as is now, but we are ready and willing and able to meet with the planning board when the town is ready.
Does SouthCoast Wind agree it is reasonable for local permitting review to proceed under the town's plan development zoning requirements before seeking exemptions from the siting board in this matter?
This is Kathleen Freeman. I think we're a different type of development project. We are under Massachusetts general laws. We are a public service company providing a renewable clean energy project which is the subject or driven by strong Massachusetts legislation and delivering huge greenhouse gas reductions, unlike a manufacturing facility or other development. Transmission projects typically seek these zoning exemptions. And I can speak as a former executive at one of the largest utilities in New England, who has seen several transmission projects through the siting board. This is a typical practice for utilities to seek these exemptions.
But earlier we all agreed, right, that in appropriate circumstances, the siting board can actually order that local permitting process to take place before granting the exemptions, correct?
Yes.
And earlier you touched upon Prysmian a little bit. That's Prysmian. And just to orient us, that involves a approximate 47 acres of the total 300-acre Brayton Point site for an offshore wind cable manufacturing facility, correct?
Correct.
And your intended project site is 10 acres?
This is Ms. Smith. The 10-acre parcel is designated for the converter station, and we would also have additional easements for installation of the underground transmission cables, adding approximately 3.3 acres. But
So
yeah,
it's
total about 13.3 acres onshore at Brayton Point as a tenant.
got it. So it's about 1/4 of the size of the Prysmian project.
Approximately.
In testimony last week, South Coast Wind acknowledged that there will be an overlap between the construction period for the Prysmian project and the South Coast Wind project, correct?
There's a potential for overlap, and it's something that we continue to monitor and coordinate on. I think what I had cited in earlier testimony was the potential for overlap onshore in early 2025 based on the current status of construction schedules.
And Prysmian has submitted an application for plan development approval and is undergoing that process right now, correct?
That's my understanding.
And the component for planning board review and comment on the Prysmian site plan has been completed and it's now back before the zoning board, correct?
I do not know the status of their project proceedings.
If that's the case, would it be reasonable and helpful for South Coast Wind to undergo plan development review while Prysmian's site plan is under review?
This is Ms. Smith. We are separate projects on the site, so I don't think that there is any cause for those to be connected. And as we're a transmission project as well, so as a result of that, that's why we're before the Massachusetts Energy Facility Siting Board, whereas that is not an applicable permitting process for Prysmian. So they have their own permitting, review, development, and construction process to follow, and it's separate from ours.
Would it be helpful when assessing the combined impacts and mitigation when looking at the site as a whole?
This is Ms. Smith again. We've addressed the need for coordination and all the efforts that both projects would undertake to minimize, avoid, and mitigate impacts in detail as part of our MEPA review process, as has Prysmian. So I think those mitigations and the strategies and the things we'll implement do go a long way to avoid, minimize, and mitigate. And so, no, I don't think that there's cause to link the two projects in their regulatory reviews.
To that, I would add, this is Kathleen Freeman. Our MEPA filings address overlap of construction activities in detail, and Prysmian is not a transmission developer for a public policy project, and they have no statutory basis for zoning exemption. And as Ms. Smith has already mentioned, we have already engaged Prysmian to minimize impacts.
The planning board's report for the Prysmian site plan was favorable in terms of recommending an approval with conditions versus a denial of the plan, correct?
This is Ms. Smith. I'm not aware of the exact status of all the documentation of their proceeding locally.
I mean, it's a matter of public record. are you saying that you don't know that the planning board has returned a favorable report conditioning or recommending conditions on the Pristmian site plan?
This is Ms. Smith. I'm saying I have not personally reviewed that document.
But that has occurred, correct?
I can't speak to that.
Would you agree that completion of the zoning board review and issuance of the plan development approval for Pristmian is expected this year?
This is Ms. Smith again. We stay coordinated and certainly.
I'm sorry, I couldn't understand you. We what?
This is Ms. Smith again. We do coordinate with Pristmian, and again, we cover cumulative considerations as part of our MIPA process, but I am not monitoring the daily or, the periodic activities under the planning board's review of the Pristmian project. So I don't have all the specific answers to dates, approvals, and whatnot associated with Pristmian.
By the way, on the issue that you talked about, hypothetical appeals of a potential approval of a site plan development review, the scrap metal operation that we were talking about at the break, which was
Wait, yeah, I'm sorry. You just dropped. Yeah, I'm sorry. You just dropped out. The scrap metal operation that we were talking about at the break.
That was enjoined by Judge Foster. That project had plan development approval, correct? It had a permit.
I apologize. The audio cut out and we lost part of the context in question.
I apologize. This went to the issue of potential appeals. And I just wanted to clarify with you, the scrap metal operation of a lessee of Brayton Point LLC that was enjoined by Judge Foster. That project had a plan development approval, correct?
Can anyone?
I don't recall. Kathleen Freeman, I believe I remember reading that there was a permit and there was enforcement of the permit, if that's what you mean.
That is exactly what I mean. And are you aware of any appeals of the issuance of the permit itself versus enforcement of permit conditions?
No, I'm not. I haven't looked into it in detail.
And aside from hypothetical appeals, in terms of timing, does South Coast Wind claim that simply undergoing the plan development review and approval process itself would unduly delay the South Coast Wind project?
This is Ms. Smith. I think we continue to come back to the point of the third-party appeals really being the concern. And we're just not able to speculate whether or not there might be third-party appeals, and therefore it's a risk to the project.
The Rhode Island Siting Board has, I'm sorry. I'm sorry.
No, just to round out my response, some of these other projects and entities at Brayton Point that we've discussed, they're not able, they don't meet the requirement of being a public service corporation. So they have their own permitting processes, they have their own reviews and their own standards to follow. And our project, South Coast Wind, is a bit different.
My questions are more targeted to the likelihood of appeals for a permit. I'm not asking what standards or exemptions might otherwise apply. So I'll move on from that. Another question I had was the Rhode Island Siting Board has stayed proceedings on the Rhode Island component of the same project, which is the subject of these proceedings, until after it has been updated on whether South Coast Wind is a successful bidder on the next round of bidding related to the clean energy resource at issue, correct?
And I'll just say that the state.
I'm sorry, who is this?
Eric Runge for the company.
Thanks.
Yeah, and so I think the order from Rhode Island EFSB speaks for itself. I don't really want the witnesses trying to paraphrase the precise words of the order here. It's in the record. And I will also add that the company has responded to that, and you'll see a further response this afternoon.
Mr.
Maybe-
Shea,
Go ahead.
what my question is targeted at, and I don't have more than two questions about the Rhode Island proceeding. It has to do with timing or delaying the project. And,
Okay.
you know, why allegedly local permitting can't go forward. So that's the only reason I'm asking these questions. So, and like I say, there's just a couple of questions about just knowledge of, how long that stay is in effect. And it's just relevant on the issue of being unduly delayed if
So-
local permitting went forward.
Right, but I understand your point. Mr. Runge, you say you don't want your witnesses paraphrasing a legal document that they don't have in front of them.
That's correct. So I think if you want to ask a factual question about delay, we can have them try to answer that. I'm just opposed to the idea of trying to have any of them paraphrase what's in that order.
Well, I can understand your objection. It may suggest one of the things that there are two possibilities. Mr. Pucci, you could read from the Rhode Island order and say, did you understand what I read? Okay, now, and then ask your question, if the Rhode Island order is going to delay all this, is there really a need for speed? That's part of my being presumptuous, what you may be saying. Or you could ask a hypothetical question. Hypothetically, if the Rhode Island EFSB has delayed this proceeding for X period of time, and then you could go on. But so I think the hypothetical, or you're reading the words from the order itself, would be the better way to go. I understand and sustain Mr. Run's objection regarding having non-lawyers paraphrase a legal document that's not necessarily in front of them. I can understand why Mr. Runge might be, and the company might be hesitant to do that.
I appreciate your guidance, Mr. Shea. I'll ask it a little bit differently. Let me ask this: termination of power purchase agreements has come up in these proceedings, correct? Witnesses.
Yes.
Okay. If South Coast Wind wants to go forward with a project related to the clean energy resource at issue, the next round of bidding for that comes up in January of 2024, correct?
In Massachusetts, correct.
I'm sorry, is this Mr. Hubbard?
Sorry, Dan Hubbard for the company. Yes. Apologies, Alan. It's
And
based on the tentative schedule that's been issued right now. We anticipate January of 24 as when bids would be due.
And South Coast Wind won't know if it is a successful bidder until June of 2024. Is that correct?
June of 24 is what's based on the draft RFP, which is presently under review, but that's the tentative schedule as indicated in that document.
And is it South Coast Wind's understanding that Rhode Island has stayed its siting board proceedings until after June of 2024?
That
After a bid has been.
So it's until after a bid has been awarded. Yeah.
Now, if South Coast Wind were to proceed with local plan development review permitting efforts, that process would be concluded long before June of 2024. Is that fair to say?
This is Ms. Smith for the project. I think, again, this goes back to the potential for third-party appeals, which is speculative at this point in time, and the concern that if that got caught up in the court system, that could take years. So any delays of that type to the development efforts of the project are damaging to the overall timeline and likelihood of success.
And just a few follow-ups on that concept of potential appeals. First of all, if the zoning board went ahead and issued plan development approval for South Coast Wind, in order for a party to appeal within that 20-day appeal period, which you earlier articulated, that party would need legal standing to appeal a permit, correct?
Emma Cashman, yes, that's correct.
Okay. And again, aside from the issue of legal standing, if anyone appealed that permit, under Massachusetts law, you can proceed with your site activities at risk, even if the permit was appealed. Is that fair to say?
I'm sorry, who was that?
I was going to say, that was already asked and I think answered, but I guess if you want to try one more time, you can.
This is Ms. Smith for the project. I think we did speak about the possibility of South Coast Wind moving forward if other permits were in hand at risk, and that's just not an advisable situation to be in. That's a major risk to the project. It's an intricate coordination of contract schedules and interfaces, and all elements of the project need to have their permits to really be sufficiently de-risked to move forward.
In terms of a potential appeal, we wouldn't know if anyone actually filed an appeal until you actually get the plan development approval. Is that fair to say?
Chairman Cashman, yes, if there would have to be a decision to appeal, file an appeal.
Now, turning to the issue of noise, are you aware that Prysmian has a current application pending before the Somerset the Somerset Board of Health for approval under the town's noise control bylaw?
This is Ms. Smith speaking personally. I wasn't aware of that particular filing, but we are aware of the noise bylaw requirements.
Has any effort been made to look at cumulative impact while construction periods overlap between your project and the Prysmian project?
This is Ms. Smith again. So I think we've spoken to the potential of cumulative overlap just in terms of the possibility that there's some construction overlap in early 2025. It's a bit early to speculate what activities could potentially overlap if overlap were to occur. And also we are working on opposite ends of the site. So I think as Ms. Wood spoke to in previous testimony, noise sources that are separated far apart spatially have limited potential to add together. But I guess in short, back to your original question, South Coast Wind has studied South Coast Wind's construction activities and operational activities.
So then I guess the answer is no, right? You haven't studied cumulative potential impact during the overlap between Prysmian and South Coast Wind.
It's so having consulted with, spoken with Prysmian and understanding where South Coast Wind is at with our project development efforts, since neither entity has their construction contractor on board, the exact phasing of various activities on site has yet to be fully determined. And so it's really, I would say, too preliminary to do that sort of detailed analysis.
The town's noise control bylaw has been marked as an exhibit as EFSB -NO-3 paren 1 close paren, correct? It's an exhibit.
If you could give us a moment to get there.
Yes.
Is that an answer? I'm sorry.
Pulling it up.
Oh, I thought I heard somebody say yes.
EFSB and 1S1.
S dash NO-3 attachment 1. I have it here.
Okay. Yes.
And either using the document or the zoning board's letter, as noted in the zoning board's May 2023 correspondence, that has an 80 decibel limit for operations 7 a.m. to 10 p.m. and 70 decibels from 10 p.m. to 7 a.m. measured at the property line. Is that correct?
Based on the letter, I believe that's what's written in the letter. I think as we discussed previously, South Coast Wind has modeled our operational noise conditions for the 55 decibel limit at residential property boundaries. And we're able to show compliance with that interpretation of the requirement.
Yeah, I'm just saying, I guess I'm asking what the your understanding of the requirement of the noise bylaw is. This is the general bylaw, not the zoning.
So this again comes back to a point I think we were discussing earlier. So originally South Coast Wind had interpreted the requirement to be 70 decibels at the industrial property boundary. And then taking into account the town's feedback through consultation, our understanding was revised through those communications that there's a 55 decibel standard at the property boundary of residential areas. So really it would be the 55 dB standard that would apply to us. So that's our current understanding of the requirement.
And in quick follow-up to Mr. Shea's questions earlier, the noise control bylaw entered into as an exhibit that I just identified is a general bylaw enacted pursuant to GL Chapter 40, Section 21. It is not a zoning bylaw, correct?
Correct. That's our understanding.
And you are not seeking to override the requirements of the general bylaw in these proceedings, correct?
Correct.
And does South Coast Wind intend to comply with the noise bylaw for both construction activities and operation of the facilities proposed in these proceedings?
So our understanding, this is Ms. Smith again, the construction bylaw does not have any quantitative limitations. I think that's due to the understanding that some construction related activities do produce noise that's temporary in nature. So there's no quantitative limit in the Somerset bylaw. But we are aware of various citations of construction work hours. And so our intent is to comply with those construction work hours to the extent practicable, but there will be instances where we'll have to seek special approval to do certain activities beyond the standard construction window. An example in our analysis was some of the HDD activities, which once they commence need to continue at for a consistent period to maintain borehole stability. So there are examples of that, but we will comply with the bylaw and we'll coordinate with the town to get those special approvals during construction.
I did not understand part of your answer there and prior testimony on this about where you come up, and maybe I'm misunderstanding it, where you come up with a distinction between temporary construction activities and longer term activities. Am I getting that correct? That you're making that distinction?
We are making a distinction.
And can you help me out where you find that in the bylaw requirements?
I think on that one, Eric Runge speaking for the company, we might want to take a record request on that one specifically.
We don't have Andrea Wood available, so.
Okay, we'll go off the record. Alan, which record request is this?
What, 23?
23, okay. I'll go back on the record request. So this would be record request RR-EFSB-23. Mr. Pucci, would you please state specifically what you're looking for?
I was looking for where the support comes from for distinguishing between temporary construction activities and longer term operations in terms of application of the noise bylaw.
Okay. Thank you.
And a related question to that, and if you don't know the answer, we could include it within 23, would be, let me ask a couple of backup questions. Also referencing the Mass DEP noise policy that you produced attached to pre-filed testimony. This is DEP noise policy from February of 1990. It's the one that talks about a requirement that a source of sound will be considered to be violating the department's noise regulation if the source, 1, increases the broadband sound level by more than 10 decibels above ambient, comma, or 2, produces a pure tone condition when any octave band center frequency sound pressure level exceeds the two adjacent center frequency sound pressure levels by 3 decibels or more. Do you make the same distinction with respect to that DEP policy as you do under the local bylaw?
This is Ms. Smith. I believe as it's laid out in our operational and construction noise reports that yes, there is a distinction so that we would comply with the Mass DEP requirements during our operational conditions. If there's a specific question about the distinction there, it might be appropriate to include as part of the record request, given that we don't
Yes,
have a matter expert on noise on today's proceedings.
Yeah, I appreciate that. So Mr. Smith, Mr. Shea, I'd like to just amend that to include also the basis for a distinction under the DEP noise policy dated February 1, 1990, for a distinction between temporary construction activities and long-term operational.
Okay. Then, do you want that to be RR-EFSB-24?
It could, or if we wanted to amend 23.
I think it'd be more straightforward if we made this RR-EFSB-24.
That's fine by me. Okay.
You understand what's being requested of you, Ms. Smith?
Yes, it's the distinction between the operational and the construction standards, right? For both the local and the Mass DEP regulations.
Yes, thank you. Does South Coast Wind intend to apply to the Somerset Board of Health for a permit or approval under the noise control bylaw?
This is Ms. Smith. I believe that there's an active record request pertaining to engagements between South Coast Wind and the Somerset Board of Health. So we are preparing a response to that, and I think planning to submit it today.
But just in terms of your knowledge today, do you intend to actually apply to the Board of Health?
Well, Ms. Smith, is your answer that that question will be answered today with a response to a record request?
That's correct.
Well, one of the things.
Sorry, apologies. I think we have to vet the due date for that, but there is an active record request on that topic.
And is the response going to be submitted today?
It will either be submitted, Eric Runge speaking, either today or tomorrow, because it would have come out of last week's questions.
Okay, because I was thinking if it came out today, then if the answer was insufficient, we could take it up tomorrow. But the question, I think, is fairly straightforward. If you can answer it,
yeah,
Mr. Pucci, you I assume that you want an answer if the question can be answered orally.
Yes.
Okay.
It seems pretty basic.
Yeah.
Okay. I'm hearing that it will be filed today, so maybe are we coming up on a break? Eric Runge speaking, because we can go and actually look at the draft response we're about to file and answer it when we come back, if that's the case.
It would be appropriate to take a break. I think it's 3:20. We usually take a 15-minute break, and then we can we'll have a little bit more than we'll take a 15-minute break. We'll have a little bit more than an hour before we have to wrap up. So why don't we do that now? It's 3:20. Why don't I see you all back here at 3:35? Thank you.
Thank you.
Thank you.
Thank you.
I apologize. I keep doing that to you. I don't put myself on camera. I've been sitting here the whole time. Sorry.
No problem. We're fine.
Before we go back on the record, I noticed Mr. Pucci's audio was cutting out a little bit once in a while, so just noting that.
So do we want to hit on the FDIR? Okay. The additional hearing.
Can you bring that
Yeah,
up? I'm sorry.
before we go on the record, are you having trouble with me, Mr. Brock?
Yes, you have. I mean, I when it was a problem, I certainly spoke up. There were 2 times when you dropped out, but we got it fixed. But just so you're aware of that possibility happening again.
Yeah, I apologize. What it is, it's the internet connection, I believe, in the office building in Boston, because I tried the computer the first day, and then I'm using my phone for these, trying to use the best way, but I can't improve their internet access, unfortunately.
Mr. Shea, one other item before you go back on the record, if you wouldn't mind.
Sure, go ahead.
It's from Ms. Smith and regards the schedule. If we do an additional day on the FEIR, I wanted her to talk about her availability because I think that will be important.
So I believe you already have Mr. Renge's availability. I will be out of office and unavailable for hearing days on August 4th, the 7th, the 8th, and the 11th.
I'm sorry, let me just write this down. The 4th, the 7th, the 8th, and the 11th of August, she'll be out.
Correct. And what were yours?
Well, just to repeat mine, and I'll add one other. They are July 28th, 31st, August 1st, and August 18th, when I need to move my daughter into her college dorm. So I can't miss that one.
Oh, this is great. Is it her first year?
It is, yes.
Oh, that's great. That's a long time ago for many of us. So you say it's July 28th, 31st, August 1st, and August 18th.
Correct.
Can we talk about that actually a little bit?
Sure.
If we're, if I can easily wrap up today, short of getting into my environmental related questions. So if we were contemplating a day because of the FEIR, I can handle all that follow-up after a siting board questions on that. But I know I'll go beyond this afternoon if I start to get into them. So do you want me to?
FEIR questions?
Well, the environmental questions. And so if we're just contemplating another day because of the FEIR, I can just incorporate the FEIR related questions into my existing outline on my environmental related questions. It's just that I know if I get into the environmental issues, and I'm not talking that I have hours and hours, but I know it will go beyond today, close of business. And I would really love to produce my witnesses to you tomorrow, because I've gone through great lengths to get, lay witnesses available and all in one place tomorrow. So, I would kind of suggest maybe that I would finish today this line of questions about zoning issues and the local noise bylaw. If I have time, I would get into vibrations and then finish with that. And then anything related to site contamination or what may be contained in the FEIR, I could just include on that other day. And then I know I can finish everything and I can produce to you my witnesses tomorrow and it doesn't result in any delay.
All right, so I think what you're saying is that we could have a maybe more expeditious resolution of today if we schedule a hearing date for the FEIR. Let me go, I don't want to give you a vague answer like we'll schedule something if possible. Let me see if we can get, does anyone, meaning anyone, would anyone object to scheduling, trying to schedule a day, another evidentiary hearing day right now so we can know future holds?
The beauty from the town's end is I don't need to check with anybody other than myself, and I've got my calendar right in front of me. So I don't know about everybody else, but I can do that right now.
Okay, how is Wednesday, August 9th for people?
I have a DPU hearing that day, 8th, 9th, and 10th.
8th, 9th, and 10th, okay.
Can we try August 3rd, Mr. Shea?
Let's see what August 3rd looks like.
Will you all have all the record requested by then, Bob?
That would be a good question. That's what I was thinking. The record request from today may be in, the record request from tomorrow won't be in. But that's not necessarily fatal. I was hoping to do it the next week. We can't do it on the 7th, 8th, and then Alan, did you say you're occupied the 9th, 10th, and 11th?
8th, 9th, and 10th.
Okay.
But unfortunately, I'm also occupied August 3, 2 and 3 next week.
Probably do the 8th, and I could swap my vacation there.
What about the 11th? Friday, the 11th?
I work Friday. I work Fridays. I'm available the 11th.
I am as well.
I could swap it on the 7th.
All right, did somebody say the 7th? Would that work or not?
I'm sorry, what was that?
The 7th of August? That work?
I think Ms. Smith is unavailable on the 7th.
I'm willing to swap my vacation days.
Really?
But Alan's not available.
No, I am available the 7th. It's the 8th, 9th, and 10th. I'm not available.
Okay.
All right, do you want to schedule our next hearing day for
Kathleen.
August 7th? Let me see if there's,
August 7th.
Yeah, I can do it.
I can make it work, but are we saying that the 11th cannot work?
The 11th
Yes.
cannot work.
Cannot work.
Oh, okay.
Sounds like August 7th is the day.
Joan, are you okay with that? 'Cause I think that's a vacation day for you.
It is, but you can go forth.
Okay. All right, so why don't we schedule our you know, I'm gonna put it on the calendar. Evidentiary hearing in okay, so why don't we schedule August 7th for our next hearing date in this case. We'll go on the record and
Oh,
state that.
Bob, may I ask a question, please?
Of course.
So in response to Mr. Pucci's schedule regarding today, finishing up the zoning matters today, present the town witnesses tomorrow morning, then we still have tomorrow afternoon scheduled. Would we start with some of Mr. Pucci's cross-examination on environmental issues in the afternoon? It seems like we've got it already scheduled. We've got folks already available that we should keep going forward. Does that make sense?
Mr. Pucci, what do you say to that? That we should maybe you can start your examination on Thursday, the afternoon of Thursday, the 27th.
Oh, okay. I thought we heard that there was a witness that couldn't be here or something. I thought
Is
we
there-
only start,
Is there a witness that's not available?
I'll have to sign off around 3 p.m. tomorrow.
Okay. That's Kelly Smith.
Yes, sorry.
That's right.
We can get some done. That's, I'm just thinking we've got it already scheduled. I'd like to get some more of it done if possible.
Agreed.
Okay. So we'll go tomorrow till 3 o'clock. If we have questions that can be answered without Ms. Smith, we'll may continue on after that. But we'll definitely schedule a hearing for August 7th. Why don't we go back on the record and we can put that on the record. I think that would be helpful, and then we know that we're all going to get a chance to ask all our questions. Does anyone else have anything to say off the record? All right, let's go back on the record. While we were off the record, we had a discussion about scheduling another day of hearings, and we have decided to schedule Monday, August 7th as our next day of hearing, as an additional day of hearings. Our next day is tomorrow, but Monday, August 7th will be an additional hearing day. Tomorrow, we also discussed that tomorrow, if we get through the town of Somerset witnesses, then we would ask Mr. Pucci to start on his environmental questions or any questions he may have after the town of Somerset witnesses, and we'll see if we have time in the afternoon, how far we can get there. Is this agreeable to all? Anyone object to that? Have anything to add? No, not seeing anything. Okay.
well, I just wanted to confirm, because some of the people I'm sure are watching in Somerset, I appreciate that of keeping our witnesses as scheduled for 10 a.m. because we've gone through a lot logistically to have them all available. And that's great. So I'll get through as much as I can today. We do the Somerset witnesses in the morning, and then whatever time we have left tomorrow, I'll pick back up. And I did want to just specify, though, if I get to be included in the questions related to the final environmental impact report on the extra day that we added, correct?
Yes.
Okay, great. I appreciate that.
Yes, that's important. All right, we are back on the record. Mr. Pucci, would you like to resume your questioning?
I would, thank you. We were talking about compliance with the DEP noise policy as well as the town's general bylaw. We left it with the record requests about support for the distinction that you're making between temporary noise impacts and longer term operational impacts, if any. So I'll just pick up on those questions. First of all, either way, if you're seeking a temporary exception or not, does South Coast Wind intend to comply with the DEP noise policy from 1990?
This is Ms. Smith. I believe there was also an outstanding question from right before we took the break regarding the Somerset Board of Health.
Oh, yes, correct.
So we can answer that. Upon review, the record request that's in process to be filed pertains to specific clauses about validating noise complaints. So I think you were asking about a slightly different provision, which is about consulting with and seeking approval from the Somerset Board of Health for our operational conditions. And yes, we will do that as part of the noise bylaw, which is separate, as established previously from the zoning bylaw.
That's for operations, but is that for construction as well?
That's for operations. We will have to respond on the distinction between construction and operations as part of the record requests taken before the break.
And I forget what my other question was that you interrupted it with that answer.
Sorry.
No problem. I was asking about DEP noise policy, I think.
Is that the active one? Kathleen, can you take that?
1991.
Sorry.
The construction, Kathleen Freeman, are you asking about the Massachusetts DEP noise policy as it pertains to construction noise?
Well, we can break it down that way. I mean, I thought we had established that South Coast Wind thinks there's a distinction between temporary impacts during construction and operations. Is that correct?
So this is Ms. Smith again. So I guess I'm not sure of the exact and latest iteration of the Mass DEP regulations. So that's why I paused on responding. But I think that we discussed earlier the Mass DEP requirement for no more than a 10 decibel increase at the property line, as well as the pure tone requirement. And South Coast Wind will comply with that during operations as stated in our operational noise report, which was attached to the original analysis, and then a revised version was provided in our information request responses. So yes, that is a requirement for us during operations.
Yeah, and we're kind of going back and forth in circles. I don't think anybody intentionally, but so whether or not there is an exception that's valid about construction versus operations.
We do have citations to our interpretation of the existing requirements as part of the operational and construction noise requirements, but I think you had asked for the basis of that distinction, and that's what we'll follow up with in the record request.
All right, so what's your other answer that you just said that isn't in the information requests? You just said you had support for something.
No, it's the topic covered in the record requests. So we can't,
Okay.
I think we decided to take record requests on them to provide the additional context you were asking for.
Yeah, right. And that's the basis for the distinction. So let me ask you a different question is, suppose you're correct that there is some type of valid exception that's legal and appropriate under both the noise bylaw and the DEP noise policy. What are your intentions for noise control in the construction period, pre-construction and construction?
Yes, we have a full list of proposed mitigations. I think they're covered in the DEIR, but if you'll allow me a minute to pull up the relevant reference.
While you're looking for that too, I wanted to specify some of my questions. You may know that the answer is in some filing or submission, in which case you could just tell me that. Yeah, this isn't a memory test. I'm just trying to, determine where that information is.
So we do have information about construction noise mitigations in our DEIR. We also are in the process of preparing and finalizing record request responses related to cumulative from various pieces of equipment in operation, as well as mitigated values pertaining to the construction operation. So I think there were 3 relevant record requests taken last week. I believe record requests 4 through 6. So those will also provide more information on the question that I believe you just asked.
And if the town were to request or the siting board were to order compliance with the town's general noise control bylaw as a condition in these proceedings for pre-construction and construction, would you object to that type of condition?
The and could you specify the standard that you're referring to?
Yes, the standards, the standards that are in the bylaw, bear with me one moment. The 55 decibels at the residential property line.
That would be.
Go ahead.
This is Ms. Smith again. So I think the results in our construction noise report show that meeting a 55 dB threshold, which is comparable to a business or like an indoor office facility, so quite quiet for frame of reference, would be a real challenge during construction.
Yeah, well, I appreciate that answer. So I wanted to just get a little detail on that. So what is intended? First of all, what are you expecting for decibel levels and for how long in terms of orienting yourself to your pre-construction and construction activities? And if the analysis is incomplete, you can tell me that. If it's reflected somewhere in a certain state of completion, you can tell me that as well. But I'm just trying to get details about what actually is intended. If you're saying you can't meet 55 decibels at the residential property line during pre-construction and construction, what is intended at this point?
So I think for that, those responses, we would refer you to the construction noise report that we submitted with our analysis, as well as the record request responses that we'll be filing.
And how about the DEP noise policy? Is that reflected in the same place? For if an exception applies during pre-construction and construction, as you're saying, what are you intending for an effort to comply with the policy?
Yes, our construction noise report filed with our analysis in May of last year includes our interpretation of the applicable regulations and modeling for our construction activities. So that would be the appropriate reference.
In terms of impact on the neighborhood, never mind decibel levels or requirements, what do you actually expect? Say you're a hypothetical resident of the Brayton Point residential neighborhood. What type of noise are they going to be subjected to, for what hours, and what recourse do they have, if any, if they perceive it to be unreasonably loud? These are just very bread and butter questions I'm asking. I'm not asking for expert analysis.
Sure. So there will be a few different phases to the construction period. We've discussed that we would use horizontal directional drilling to make the cable landfall, which is a method of drilling from an onshore setup to an offshore setup. That activity has drill rigs associated with it and various other support equipment that is specifically modeled and discussed in the construction noise report that I previously referenced. Our estimated duration for the horizontal directional drilling operations for the project and the notice variation is a total of approximately 2 to 4 months. But the noise sources, it will be intermittent, and there will be some variability to what various equipment is in operation at what points in time. We are also proposing to use equipment silencers for the exhaust from those equipments, as well as temporary mitigations like a construction noise barrier, which was the topic of, I believe, record request 5 from last week, that we'll be providing more information on. So that's just a bit of context on the horizontal directional drilling activities. Inland, we will use standard utility style construction methods for open trench excavation to dig a trench along our proposed cable route, where we will lay conduits. So those are essentially pipes that we'll place into the trench, backfill concrete, and then backfill the excavation and restore the access road. So that type of construction equipment is going to be in line with standard excavators and whatnot that you would see with a standard utility style project in roadway. There's also information about the sound levels from that type of equipment in the construction report. At the converter station facility itself, there will be some grading activities. We'll do some work to install what I've referred to previously as the ground grid for lightning protection. Also, foundations will be installed for the buildings of the converter station, and bus bar and steel erection. So that's the type of construction we're talking about. And as shown in the construction operation report, you can see that the berm to the east of the site, which is again about 30 feet tall, does a good job of mitigating quite a bit of the visual and noise and dust as well related impacts from construction activities. So each of these phases of the project has its own estimated duration, but the exact phasing will be determined as we get a construction contractor on board. I think Ms. Perry could speak to it further, but during construction, we will have a dedicated web page. I don't know if you want to comment on that.
Yep, this is Kelsey. During construction, we will have a dedicated web page to be able to alert residents, other stakeholders, and interested parties to our construction dates, times, activities, where we'll be and when.
This is Kathleen Freeman. Getting back to your question, Mr. Pucci, about the noise policy, I refer you to the First Circuit decision in Town of Weymouth versus Mass DEP, issued in June 2020. In that decision, the First Circuit stated a Mass DEP has a long-standing practice of not applying the noise policy to temporary construction sound for purposes of air compliance or permitting, and instead Mass DEP and the siting board have required appropriate noise mitigation measures during the construction period. For example, Mass DEP has required mitigating measures for the construction period, such as limited construction hours, mufflers for heavy equipment, corridor backup alarms, portable noise barriers, and noise and a hotline for citizen concerns. And I believe that is all addressed in our previous filings, especially in our MEPA filings.
I believe the appropriate references, this is Ms. Smith again, for our responses is the company's response to SOM 8 and SOM 10, which were the information requests filed by the town of Somerset.
That was for the exception, you're saying?
That was just explaining mitigations and construction activities and noise related considerations.
And how is South Coast Wind intending to deal with noise issues vis-a-vis the local bylaw and the Mass DEP noise policy? If there are complaints or enforcement issues, are you treating them as two separate issues? In other words, town enforcement and town engagement under the bylaw versus just enforcement or dialogue or engagement with Mass DEP on the policy? Or is it going to be a combination, or have you not figured it out yet?
So Kathleen Freeman, can you restate the question? I thought we were pretty clear that the noise policy per the First Circuit is not, as a matter of practice, applied by Mass DEP to temporary construction sound, and mitigation measures are the focus.
Right. So on the mitigation measures, are you treating it as combined under the town bylaw and the policy? In other words, something short of the requirement of the policy, but some type of engagement on a mitigation process. Are you combining compliance with or attempted compliance or as practicable types compliance with the noise bylaw, with the DEP policy, or have you not thought it through that way?
This is Ms. Smith. I think we're still maybe a bit confused about how to interpret the question. I would say compliance and mitigation are separate topics.
Right, just stay on mitigation. In other words, I'm assume the validity that there is an exception to the Mass DEP noise policy.
For construction?
Yes.
Okay.
And assume also that somehow you've come up with an exception to the town's noise bylaw on the 55 decibel requirement. In terms of talking about mitigation or dealing with complaints, if something is particularly bad on a particular day or night or period of time, are you combining that process, or are you considering Mass DEP one entity to deal with and the town potentially another entity?
Yeah, our understanding would be that they're separate entities with separate requirements. So I'm not sure that there is a way to combine the process.
Right, there might not be. I'm just trying to get clarity on it about, who's going to be monitoring what. Because if you're saying that an actual measurable requirement wouldn't apply during this period, I'm just trying to figure out what the company's intentions are for dealing with mitigation issues, if there's a complaint, if something is particularly bad or unusually bad, or some, intolerable noise level is coming out of the pre-construction or construction activities.
Eric Runge for the company, just to clarify, are you asking if there's a complaint with the town about a violation of the noise bylaw? I think if that's the case, the company would address that with the town. If it's a complaint to the DEP somehow that its requirements are violated, then the company would address it with the DEP.
I think that answers it. So I'll move on from there. You had mentioned earlier, I'm trying to cross some things off of my outline in reverse order. You had talked about a communication plan, I think, with the town. You recall that? This is with regard to pre-construction and construction. I think Ms. Smith, maybe, or
This is probably for me. This is Kelsey speaking.
Kelsey.
What plan are you speaking about?
In my questions just now about, dealing with potential mitigation of construction and pre-construction noise generating activities, is there some type of communication plan with the town in that regard?
This is Kelsey still. We will develop a communications plan for construction prior to construction. It has not been completed yet, and we'll consult the town on matters related to traffic, where to get information out to the community and things like that. But SouthCoast Wind will develop that plan.
And there's nothing either through the MEPA filings or these proceedings, evidentiary or information responses that provide any details as to that plan. Is that right at this stage?
That's correct at this stage.
All right. Another issue was a construction management plan. I haven't gotten to that part of the FEIR, but has SouthCoast Wind produced a construction management plan?
Let me just get it. Kathleen Freeman, we will produce a construction management plan, which is a quite.
I'm sorry, I lost a couple of words.
Oh,
What?
We would produce a compiled construction management plan. At the point we have final design plans and closer to construction. And that is explained in our FEIR, and I'm just looking in the FEIR now to give you a page reference. Hang on. That would be section 7.1 of the FEIR, starting on page 7-1, and basically consistent with industry practice, the construction management plan will be prepared closer to the construction start, which is currently projected to be as soon as early 2025. The construction management plan will be finalized through permitting, the MEPA process, and reflect current site conditions after the landowner completes its site improvements in the project area, as we have discussed earlier today, and after SouthCoast Wind hires its construction contractors and incorporates their construction management information. So SouthCoast Wind prioritizes effective construction management and will select contractors largely based on their performance on prior contracts, including consideration of their careful management of environmental issues. So the construction management plan, in my experience, having done these for a major utility, is they include a lot of other plans, including the soil management plan, the stormwater management plan, the permits, the permit conditions and commitments. It's a comprehensive document, which is quite extensive. Yep. Anything?
Yep, sorry. Anything further? Did somebody try to talk and I interrupted them?
Again, I just want to stress that the construction management plan will reflect permitting updates and include permit conditions, other monitoring plans, and commitments made during the environmental review process under MEPA and other processes.
Right, that makes sense. I'm sorry, Mr. Shea. Go ahead.
I apologize. I just don't forget this. I just asked Ms. Freeman. Can you tell me about the town of Weymouth versus Mass DEP First Circuit? Do you have a citation of the date of the decision?
I have a June 2020, but I can get you a citation if you give me a few minutes. I'm sure I can find it. We reviewed it carefully when we were preparing our supporting analyses for the EFSB petition we filed last year.
That's right. If you've got the month and the title of the case, I'll be able to find it myself. Thank you. I'm sorry.
Yeah.
I just didn't want to forget.
No, I'm sorry, Mr. Brock. Did I talk?
Go ahead.
All right. No, Mr. Shea, I thought that ended up being the answer that's going to come in one of these record requests, or in terms of earlier, I asked about where the support comes from for this exception. And I think that's the answer. So I would imagine that the full citation or any other support for it will come in that response as well. That's what I was expecting. But is that, can I ask that? Can I just ask, is that clarifying, or does SouthCoast One intend to look into the matter further and possibly provide further information in those response to those record requests that were just added? Or do you think that that's the answer, that one First Circuit case?
We could provide it, but if you Google Town of Weymouth versus Massachusetts Department of Environmental Protection, number 19-1797, First Circuit 2020. Yeah, let's see. I don't need legal. I don't need legal research.
Wait.
I don't need legal research tips. I just am trying to clarify what's going to come in the answer in the response. Is it anything further than that case as support for the exception?
Mr. Pucci, Eric Runge for the company. So we will take under advisement what our answer will be, and you'll get that when we submit it.
Okay, thank you. I'm just trying to clarify that. I forget where I was. Bear with me 1 second.
Just one second, please. Just 1 second. Okay, thank you.
Thank you. Ms. Freeman, I have to agree with you about a construction management plan. You got to be much farther along in the process than this to have a meaningful one. I was surprised about the requirement I think it was on the Secretary's certificate on the draft environmental impact report. Is that right?
Yes, Kathleen Freeman. Yes, that is correct.
And so are what you're saying is in the FEIR, you're not producing anything in response to that requirement. There's a section explaining why that's not being produced at this time. Is that fair?
Yes, that is correct. It is industry practice to do it closer to when you're ready for construction. I've seen purported construction management plans by other offshore wind developers, which in my opinion are not construction management plans because they are voluminous and they're typically a compilation of several other plans. It's like a guide that's used for compliance and having prepared just the outreach chapter of one construction management plan for the Northern Pass project, that was several inches thick. So yes, it is a voluminous document.
And would it make sense to you that, especially in light of the type of site that we're talking about, that involves, potential management of contaminated soils, staying in and out of those areas and what happens if contamination is encountered, that it would be a reasonable condition to have peer review input into that construction management plan.
Kathleen Freeman, my understanding is that these plans are a compilation of plans that would have been reviewed by regulators, like the URAM, the Utility Release Abatement Measure Plan, would have been submitted to the Massachusetts DEP and reviewed by them and publicly available. So what we would be doing is taking the permits that had already been reviewed after the MEPA process and all these other plans. I believe we are planning to submit tomorrow a list of the plans that are typically included in a construction management plan. Council, perhaps you can provide more. We've already prepared the exhibit.
Yeah, Eric Runge for the company. Just to let you know, we do have a supplemental filing to, I think it's SOM-10, that's SOM-10. And in that, we will talk about the company's commitment to make the filing of the construction management plan in accordance with best industry practices and in compliance with all applicable regulations. That will go in. There will also be a list, an illustrative list of the components of that construction management plan that has been carefully reviewed very recently, in fact, by Kathleen Freeman and others here. So that, as I said, will be going in tomorrow. It is not the construction management plan, which of course cannot be compiled now, but it will tell you what will be done. And it will also have a commitment that we would make a filing of that plan once it is actually created.
Yeah, and would South Coast Wind be agreeable to peer review on behalf of the town of Somerset into site plan issues, issues that would be addressed in a construction management plan?
This is Ms. Smith speaking. The aspects of the construction management plan that are developed in consultation with the town will be reviewed by the town. Other aspects of the construction management plan that are reviewed with other regulatory agencies, that would be their process. So not everything.
How about peer review with specifically a licensed site professional and an industrial hygienist to act as peer reviewers on behalf of the town? Would South Coast Wind be agreeable to that type of condition?
South Coast, this is Ms. Smith again. South Coast Wind will follow the requirements of Mass DEP. So we'll be engaged with Mass DEP as the regulatory agency, and they'll be responsible for the review of our materials. So they would be the reviewer of interest on this.
Moving on to vibrational impacts. And I know we talked about horizontal directional drilling. So you can include this in your answer, but I'm looking for all impacts. What vibrational impacts are expected for residents in the Brayton Point residential neighborhood related to pre-construction and construction activities?
This is Ms. Smith for the company. Most of the activities would not produce anything of note from a vibrational standpoint. In particular, I guess I'll speak to horizontal directional drilling first. In some applications, there can be a use of what's called an overwash casing, which is something that could be driven into the ground using a hammer type tool to provide additional stability for the shallow portion of the horizontal directional drilling activities. And whether or not an overwash casing is used is typically something that's at the discretion of the contractor based on site specific conditions. In consultation with our drillers and engineering resources, our understanding is that for the horizontal directional drilling activities, that would be something that would be most likely to produce vibrations. However, the feedback was that given the distance from our onshore horizontal directional drilling setup to the nearest residences, no impacts would be felt at that distance. So it's something that will be our understanding of whether or not those sorts of installation techniques are required
will be refined during detailed design once we have a construction contractor on board. And we'll follow the necessary mitigations and continue to keep track of it. But at this point in time, we don't foresee any vibrational impacts.
And for vibrational impacts generally, do you foresee anything, any potential other than related to horizontal directional drilling?
Not at this time, but again, it's something that we'll continue to monitor during the construction or the engineering, detailed engineering and pre-construction processes.
And I'm sorry, are you saying that there will be no vibrational impacts in the residential neighborhood actually during HDD operations?
That's the initial feedback we've gotten from interactions and discussions with drilling contractors.
And can you tell me, is support for that proposition contained anywhere?
It's based on construction contractor experience with past projects and examples of where monitoring has been employed and found no impacts in much closer in much tighter construction areas. So it's based on construction contractor anecdotal discussions.
Can you cite to any specific studies that you've either had prepared or reviewed with regard to that issue?
Not specific to SouthCoast Wind at this point in time.
Anything, say I'm a resident in the neighborhood and I'm disturbed and I think the pictures are going to come off the wall and I'm going to have cracks in my foundation. I'm going to have headaches and nausea. What would I Google to alleviate my concerns? Have you discovered any literature in that regard that there's nothing to worry about in terms of vibrational impact?
You want to add anything?
This is Tim Ryer. We don't have anything specific to cite at this time. Just to reiterate what Ms. Smith mentioned is that, this is part of the detailed engineering and construction planning process, and we'll work with our selected construction contractor to implement the necessary mitigations if the concerns are, found to be relevant.
Yeah, that was my next question. If there was going to be any impact, has any type of mitigation measures have any been considered? Doesn't sound like there have been.
At this time, because this is Ms. Smith again, at this time, because we don't foresee any impacts, no mitigations are being proposed.
What do we think of the issue of on the 2 to 4 months on the HDD period? What do you think is the best case scenario for that and a worst case scenario? In other words, is it possible to be shorter than 2 to 4 months?
This is Tim Ryer speaking here. I think we've defined what we expect to be the range of durations in that, just as you stated, the 2 to 4 months. So that's our.
I'm sorry. We expect to see the range of durations. What?
The range of durations, as you stated, being 2 to 4 months in the range that we provided. We still believe that to be an accurate estimate.
How about worst case scenario? Would it be beyond 4 months?
This is Tim Ryer. That's our best estimate at this point. I mean, there's always a possibility that activities extend further. We can't say conclusively that it's not going to be 4 months and 1 day, but that's our best estimate for a conservative range of durations at this time.
Earlier, you testified turning to stormwater management. There were some questions from Mr. Shea about the Mass DEP stormwater regulations, Mass DEP regulations in that regard. Is there a local stormwater bylaw applicable to the project?
This is Ms. Smith. I believe that Somerset has adopted the Massachusetts stormwater standards. We might have to follow up with more information on whether there are more stringent requirements at the local level.
In terms of if there are not more stringent requirements at the local level, with regard to stormwater management compliance, is that subsumed within the application process to the Conservation Commission for approval under the State Wetlands Protection Act, or does that come at a different phase?
This is Jamie Duran from Power Engineers. So yeah, compliance with the Massachusetts Stormwater Handbook and Stormwater Standards will be incorporated into the notice of intent that be filed with the Somerset Concom.
So the Conservation Commission gets first crack at it. If you're satisfied with those conditions, that's the permit. And if you're unsatisfied, you go to Mass DEP for superseding order, correct?
Yes, that's correct.
Okay. In terms of stormwater requirements, are there any other requirements you have to comply with, like under the NIPD's permit or any Clean Water Act or anything like that? Anything beyond the Mass DEP compliance?
Yes, this is Jamie Durand again. So yeah, as we talked about the other day, and as you just mentioned, we will need a NIPD's, NPDES permit, general construction permit for the construction of the onshore portion of the project, and those will dictate what our inspection and best management practices and reporting requirements will be throughout the construction phase of the project. Also mentioned water quality.
I'm sorry, couldn't it also mentioned what?
That the water quality certification regulations, and there are certain regulations pertaining to obviously maintaining water quality from not only construction phase of the project, but any discharges from the site. So yes, there will be a review not only from the Conservation Commission level, but the Massachusetts DEP, and also through the federal US EPA for the NIPD's construction general permit.
I'm sorry, also through the federal US EPA, what?
NIPD's NP.
Yes.
Yes, construction general permit. Sorry about that.
Will South Coast Wind and Prysmian be drilling, expediting, or excavating or constructing with overlap periods of time?
This is Ms. Smith. I think this is a topic we touched on earlier. Based on the current understanding of both project construction schedules, there could be overlap in, excuse me, in early 2025, but the degree of overlap and what potential activities might overlap is something that we'll continue to monitor and have a better understanding of when both projects have their construction contractors on board.
All right. I asked a little bit about this earlier about vibrations. Do you know if there are any actual standards or requirements for vibrations related to the construction of the project? For compliance, either local, state, or federal?
I guess one thing I'd like to mention, just I guess from a high level, is the contractor is brought on board specifically, horizontal direction drilling contractor that may be putting in casings in or putting in temporary sheet piling. And obviously, we're working where there are other infrastructure. There's other electric transmission facilities. There's also underground facilities like the Breaking Point facility. There's switching stations and electric substations. And a little further off the Breaking Point, there's a natural gas regulator station. So they're all going to be concerned with vibration. So I think as the contractor comes on board, we'll just, there'll be certain requirements from those utilities. I don't have those right now, but there will be those utilities will express what their requirements are for vibration, and the contractor will have to adhere to those.
And aside from what they're going to intend for what they'll require, are there any local, state, or federal requirements specific to vibrational impact that you're aware of?
Not offhand, just as an anecdote, we were, as Kelly mentioned, we worked on another project where it was an underground project through a densely developed area, an urban environment, where we were adjacent to historic structures and buildings. So that was more of a, came from a historic commission that they required.
I'm sorry, so that was more of a what?
The historical commission concern, where they requested that we do a structural inspection of some of the older buildings and do some monitoring. But other than that, I haven't seen anything particular offhand that I can recall.
Has South Coast Wind conducted any assessment regarding vibrational impacts, potential adverse impacts with regard to contaminated areas subject to an AUL or otherwise?
This is Ms. Smith. We don't foresee any correlation between where our facilities are proposed and the construction activities and the in situ conditions in the neighboring area.
How about in terms of, seismic effects, vibrations from areas that are not subject, that are not in contaminated areas, but are in the vicinity of contaminated areas? Have you done any assessment on that issue?
This is Ms. Smith. So to clarify, is the question vibrational impacts on soils and subsurface materials nearby?
Correct. Let's start out. Why don't we just start out concrete with, the lined, the site, the part of the site that you're building on that you talked about earlier in the proceedings. It wasn't the area subject to the AUL that you said Brayton Point LLC is either going to move, or if they don't move it, you're going to engage in some sort of process for figuring out how to build on it. Is that a fair characterization of the testimony?
The areas in question with the activity use limitation in cell 1A are outside of South Coast Wind's proposed parcel. But yes, I follow what you're speaking about. And specific to construction related activities and potential interactions with those areas, South Coast Wind plans to develop a utility release and abatement measure plan, a URAM plan. So it is pretty standard practice to have some kind of plan in place for construction activities around these sorts of environmental considerations. I don't think there's any particular unique concern related to vibrations.
Okay, I mean that. Have you assessed the issue? In other words, do you have any support for what you just said? That no concern. We're doing horizontal directional drilling. It's going to have some vibrational impact, but it's going to have no adverse impact with regard to either contaminated areas subject to the AUL, ash pits, or any potentially contaminated areas that have not yet been revealed on testing. Have you done any assessment in that regard?
This is Tim Ryer. I can speak to it. We have not specifically assessed that, but we at this time did not believe that assessment was warranted based on the nature of the activities that we're proposing and the potential for interaction. Go ahead, Kathleen.
And Kathleen Freeman, our HDD operations are nowhere near the AULs, the Massachusetts Contingency Plan regulated activity use limitations you mentioned. We've carefully cited those operations to avoid those areas. And we do have an active record request from the siting board, which we are responding to today, which will address the landowner's proposed activities in the AUL covered by our release tracking number 4-136 131 is it, Jamie? 1316. So the AUL area near our proposed converter station, they're planning to take some of that AUL area and almost level it at, but not move the AUL area. And then they'll take some of that AUL material and move it to landfill cell 10, which is I believe the remaining open solid waste landfill cell. And we are submitting today a copy, as requested by the siting board, a copy of the latest, the June 2023 landfill cell 10 modification plan. And we anticipate that the landowner's licensed site professional will also be following suit with the Massachusetts contingency plan companion to that filing.
Thank you. Right, cell 1A, the AUL that you're referring to is RTN 04-0013-169, correct? That's
Yes.
the one you're talking about?
Yes, thank you, Mr. Pucci. That is correct.
No problem. So let me break it down a little bit. Certainly horizontal directional drilling is not contemplated into 13169, right?
Correct.
You're not gonna drill into that area.
Correct. We're not proposing horizontal directional drilling activities or any construction activities within the AUL area.
Okay. And how about these other cells that are located like in the vicinity of the Lee River? Are you snaking in and out of that area, or are you going straight through? Kind of picture, my questions are very common sense right now. They're not, they don't call for expert conclusion. Think of it like a minefield, that you have ash pits and you have other, potentially contaminated soils.
This is Ms. Smith. The proposed siting for our underground transmission facilities and the construction areas are located outside of closed landfill cells, as well as the activity use limitation area. We do acknowledge that it's a brownfield site, and so we will be in proximity to some of those areas, but we're not proposing to site within them. And I guess to further emphasize the point made previously, in the handling of such material would be managed via a URAM plan in consultation with Mass DEP.
Okay, in relation to that, in the MEPA filings, CZM had submitted comments, capital CZM, and they noted that for this area, the one, first of all, that we're talking about, the AUL in your direct project area, 13169, it said that there is a, quote, high potential for encountering contaminated soil when performing excavation for the HDD entrance pit, trenching, and site prep for the proposed converter station, close quote. And I'm quoting from the MEPA filings. First, my question is, do you agree with that? Or has that been refuted in your filings? I can read it again if you want.
Yes.
I'm sorry, who said yes, please?
This is Ms. Smith. I might have found the reference, but if you could read it again, that would be appreciated.
Yeah, the part I'm referring to is where they say, and this is specifically with regard to concern in this area of the AUL, quote, there is, quote, high potential for encountering contaminated soil when performing excavation for the HDD entrance pit, trenching, and site prep for the proposed converter station, close quote. And what my question is, do you agree with that, or has there been further information developed to either question or refute that?
I guess this is Ms. Smith speaking generally, and then perhaps Ms. Freeman will want to add on, but we are aware that it's an existing brownfield site and there has been legacy contamination And so we will do the necessary pre-characterizations and develop the URAM plan to characterize the management of that material. But yes, there is a possibility that we encounter something during our excavation.
All right, and you've described what your plan is for dealing with that?
Well, we'll develop the plan in more detail, the URAM plan.
Just bear with me, Mr. Presiding Officer, one moment. I'm trying to see if I'm wrapped up on anything other than questions that are related to further information that might have come out of the FEIR.
Mr. Pucci, this is Kathleen Freeman. I don't know if this is helpful. We do address all the comments that were received from CZM and other commenters on our DEIR. We address that in our FEIR. We are required to include the comments and to include how we have addressed them. But to add to what Ms. Smith said, given the historical use of Brayton Point for decades as a coal-fired power plant, yes, we anticipate we may potentially encounter hazardous waste and oil contaminants during construction. And in order to best address this, we are making use of the Mass DEP's MCP mechanism, which is utility-related abatement measure under 310 CMR 40.0460 and that sequence. URAMs are typically undertaken at brownfield sites such as Brayton Point by persons overseeing or directly responsible for utility construction activities, such as the installation of transmission infrastructure, duct banks, manholes, HDDs, transition joint bays, converter stations.
I'm sorry, transition what?
Oh, my apologies. Transition joint bays.
Thank you.
Which is involved with the HDD we were just talking about. The URAM plan would specify and allow for the management of excavated and disturbed soil during construction activities and the implementation of required health and safety protocols during the work, including dust control or the disturbance of soils. And we've already consulted with and will continue to consult with the Massachusetts Department of Environmental Protection regarding the management of potentially contaminated material by the project. And that is significant because we've been speaking to the Mass DEP Southeast Regional Office leadership, who are very familiar with the conditions at Brayton Point and have provided good guidance to us on how best to manage it. They've been tracking all the work that's been done at the site over the years, including enforcement actions, consent orders. So we will be continuing to work with the regulators on this to ensure that our URAM plan covers all the bases, and that will be publicly available on the Mass DEP sites lookup site. We can certainly let the town know when it's uploaded and available for review.
No, I understand that. So in terms of, site analysis, surface and subsurface soil and groundwater, boring and well sites that are intended, you don't know yet what you'll be doing yourself in that regard to do your own site assessment, as opposed to data that's already in the record through Mass DEP or otherwise.
I should mention that in consultation with council and in order to establish our liability protections as innocent tenants, we have conducted the ASTM phase 1 and phase 2 assessments, which are confidential because they were prepared for seeking a legal opinion for establishing liability protections under the federal and state Superfund laws. So we have in fact done pre-characterization. However, as we draw closer to construction, we will do a refresh to confirm our understanding of conditions in our project area.
Can you, you say they're confidential, can you, so without saying what the substance of them are, if they're confidential, you can't tell me what exactly was tested or where wells were dug or anything like that?
I can generally paraphrase that borings, test pits, and wells were placed in the proposed project area, and we tested for the contaminants that standard contaminants and those that would be expected at the site. And based on the groundwater testing that was done, no reportable conditions have been indicated by our own consultants' testing.
And actually,
Metal and
I'm sorry, you have been indicated by our own consultants testing, then I
Yeah.
didn't hear you.
Yeah, we tested for metals and the contaminants that have historically been reported at the site by numerous environmental studies.
I apologize for interrupting again. New Moon Environmental Studies?
I apologize, numerous.
Oh, thank you.
regardless of whether you consider those confidential now, if reportable concentrations had been revealed, you would have been obligated to report that, correct?
If reportable concentrations were revealed, we would notify the landowner for their legal team to assess their reporting obligations as a I don't think we're officially a tenant yet, but we would report it to the landowner as Prismium did based on their ASTM testing in January this year. And I believe that Prismium reported that information and that a notice of responsibility was issued recently by Mass DEP to the landowner. And that is a public record in the Massachusetts sites lookup.
Right, thank you. And what contractor or contractors were involved in the phase 1 and 2 assessment that you did?
Kelly, you want to take that? I mean, I think we just spoke about those being confidential documents, but they are reputable contractors, and just, I guess, to offer it up, it was GZA Geoenvironmental.
GZA?
Correct.
GZA Geoenvironmental? Correct.
Correct.
Were there any other consulting firms involved in that?
I think Freeman Power Engineers did the ASTM phase 1. And
Wait, Kathleen, sorry. What did you say?
Power Engineers
Okay.
Conducted the ASTM stands for American Society of Testing and Measures, which establishes the standard for doing these assessments. So ASTM phase 1 was done by Power Engineers. ASTM phase 2, which involved the test pits, the soil testing, and the groundwater testing, was done by GZA Geoenvironmental, as stated by Ms. Smith.
And what was the time frame of that entire process for both the phase 1 and the phase 2?
Speaking to the phase 2 environmental site assessment, that was done in the fall 2022. So that's when the site investigation was conducted.
How about the phase 1?
That's a desktop evaluation. I don't have the exact date.
Makes sense. Okay.
This is Jamie Duran. I believe it was done in the time frame between, I think, the fall of 2021 into the spring, early summer of 2022.
Okay, and then what I was asking about specifically, what would be actual field work? Like what was the time period of the field work?
I think
That would have, I'm sorry, that would have related to the phase 2, correct?
this is Ms. Smith, correct. So that's the answer I provided just a moment ago.
And was it as clarified by that gentleman? I didn't see him. Was that the period of that site work, or are you
No.
saying a different?
No, the period I stated was the period for the phase 2 environmental site investigation field work. And that was in the fall, late summer, fall of 2022.
Okay, thank you. Earlier, I think in response to Mr. Shea, you had talked about the ground lease with Brayton Point LLC. Is that correct?
Sorry, what was the question?
I think somebody testified to a ground lease with Brayton Point LLC.
This is Ms. Smith. We spoke about an option to ground lease agreement that we have in place.
An option to ground lease agreement. Okay, and is that the document that's going to be produced in response to the record request?
No.
All right. What am I getting wrong? Are you following me, or?
I can follow up on that. Eric Runge for the company. The record request was to file the actual ground lease when it is executed. So it's to be determined when that gets filed. And it would be filed under a motion for protective treatment, as I said.
Okay, thank you. So how about the option to enter the ground lease? That's probably signed and sealed and delivered, correct? Option to enter ground lease?
That's Ms. Smith. That's an active agreement.
I'm sorry, I'm sorry, I didn't hear the answer.
That is an active agreement.
Thank you.
And can that be produced?
This is Dan speaking on Dan Hubbard on behalf of the company. We'd have to just review it to ensure confidentiality between the parties is not tripped, but we can return on that.
Yeah, could Mr. Shea, could I ask that? Could I add that to the record request?
Well, why don't you ask this as a record request?
I think, did I? I thought I just did to you.
We'll give it a number, but tell me specifically what you're looking for.
The option to enter into ground lease between SouthCoast Wind and Brayton Point LLC.
Okay, the option to enter into the ground lease is Mr. Runge. Can I ask Mr. Runge, is the option in existence?
I just established that with the witness.
Okay, all
Signed,
right.
sealed, and delivered. Yes.
So, all right. So which I'll ask Mr. Brock, which record request is this?
It's 25.
RR-EFSB-25. Mr. Pucci has asked a record request asking for a copy of the ground lease, the option to enter into the ground lease. And as Mr. Runge pointed out, the ground lease itself is a subject of a separate record request. It's 6 minutes of 5, Mr. Pucci. Do you want to wrap up?
Yes, if I could move along very quickly, I wanted to wrap up and make a suggestion on the where I go from here.
Mr. Runge, I'm sorry, go ahead.
Just wanted to follow up on the record request itself. As I stated, we're going to look at it. It might be filed under a motion for protective treatment. And if it is, we will need a non-disclosure agreement with the requesting party, the town.
Do you want to file it with a motion for protective treatment and a proposed non-disclosure agreement?
That is probably what we will do if in fact we determine it's something that's confidential. So yes.
Okay, that often works well, rather, to get a proposed non-disclosure agreement rather than just leaving it up to me, where I may, better than I do what's confidential. So that's record request RR-EFSB-25. Now, the other thing we were talking about, Mr. Pucci, was it's a few minutes before 5.
Right. If I could just finish this little line of questioning, and then we could just address that it's 5 minutes to 5. It would take less than a minute probably on the follow-up questions about the ground lease and stuff.
Yes, sir. Go ahead.
Just SouthCoast Wind witnesses, are there any other written agreements in effect presently between Brayton Point LLC and SouthCoast Wind?
Yeah, not to the best of our knowledge.
Sorry, who is that?
Dan Hubbard for the company.
And this may be confidential, the answer, but I'll ask it anyway, and you can tell me if it's confidential. Are there presently any limitation of liability or indemnity or any agreements along those lines between Brayton Point LLC and SouthCoast Wind?
I think we can probably address that in the records request 25, because that's essentially the whole agreement.
Very good, thank you.
Mhm.
So Mr. Shea, it being now 4 minutes to 5, what I would like to do is just combine my remaining questions regarding environmental issues to the questioning related to the FEIR, because a lot of my questions, the answers might be in the FEIR.
Okay.
And would serve everybody well if we didn't have to go through those like needles in the eye. So what I would propose doing is I'm done with my questioning on zoning and all those other issues. The only issues I had left were environmental related issues related to the site. I can subsume all of that questioning in on the day of when we deal with the FEIR.
Okay, and if no one objects, like Mr. Rund, you may have redirect, or someone else in the may have more cross, but I'd like to stay everything until tomorrow morning. We'll all be together tomorrow at 10. And I know that tomorrow at 10 we're scheduled to question the Somerset witnesses, but let me ask Mr. Runge, do you have redirect for your witnesses?
Not today. It's possible I could have something tomorrow, but I don't think so.
Okay.
You think that I would like to have a discussion, doesn't have to be right now, but maybe before we go on the record tomorrow, about what witnesses you might think would be needed for the FEIR discussion. And by that, I mean specifically, do you think you need some of the more expert witnesses on noise or similar matters? I don't think you do, but I just wanted to know that.
That's a really good point. Why don't I'm glad that you brought that up. Why don't we all think about it and we can talk about it before we go on the record tomorrow?
Okay.
Does anyone have anything else to that we need to address today? All right, not hearing anything. It's been thank you all for showing up. Thank you for being prepared. And we will see each other at 10 a.m. tomorrow morning. Thank you.
Thank you.
Thank you very much.
Thanks.